Boom. All right, let's go. All right, share my screen. Let's get it. All right. Let me know if you're able to see the PowerPoint. Can everyone see the PowerPoint?
Yes, sir.
Yes.
Yes.
All right, cool. So now that we're about to start, I'm just going to ask everyone to go on mute. There's going to be a lot of stuff going on. Some of the stuff you might be hearing for the first time. Some of the stuff, if you've been following me for a while, you're going to hear some of what I'm going to say again. But most importantly, please take very good notes, because if something applies to you, you definitely want to make a note of it. And if something applies to you, you want to make a note of it and touch base with me later on. And if we need to go over it for further clarification, I have some questions built in to the back end of the Zoom, like further down, that we will be going over. It's going to answer a lot of y'all questions. But for the questions that are not covered, I definitely want y'all to make sure that y'all are writing your questions down. So I won't be taking any questions until towards the tail end of the Zoom. So as you can see, this somebody is unmuted. Please mute, or I'll just mute everybody. Nish, could you just mute everyone?
Okay.
Okay, perfect. All right, so let's go.
You got to remember, once I do that, you have to unmute yourself.
Oh yeah, I'm over here talking. Can y'all hear me now?
Yeah, they'll hear you now.
Yes. Talking to that glass, aren't you?
All right, let's go. Let me change this view to here. So, okay, boom. All right. All right, so basically, let me teach you how to get rid of collections. That's why we're here tonight. For those of you who don't know, but everybody should know, we officially launched the website. Can y'all still hear me? Yes? Yes, Nish?
Yes.
Okay,
Yes,
good.
we hear you.
Okay, because I removed the thing so I can see the screen. All right, so as you know, the website is up. This handsome guy and all the ebooks and the products are there on the website. So if any of y'all didn't get a chance to do that, please go check the website out and get your copy of the ebook, because the ebook is absolutely critical to teaching you how to get all of your consumer reports the way you want it. So you'll be able to take what you want off, put what you want on, and vice versa. All right. So we're going to start off with as you know, we're discussing the Fair Debt Collection Practices Act, and the biggest question is, what is debt? So before I go into the whole spectrum of the law, we're going to define what debt is, and this definition came directly from the Fdcpa under 15 USC 1692A5. The term debt means any obligation or alleged obligation. Look like somebody's marking on the screen. I'm not sure how that works. Nish, are you able to remove that, please? Or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, insurance, or services which are the subject of the transaction are primarily for personal, family, or household purposes, whether or not such obligation has been reduced to judgment. And for those that are just coming in, if you're not muted as you come in, please mute so there won't be any interference in the audio. All right.
Okay, but before we continue,
Go ahead.
Sorry for Kavi. But before we continue, they will all be muted upon entrance unless they unmute themselves. And if someone's trying to follow the what Daraine is teaching on screen, try not to, if you're using an iPod, to draw your finger on screen because it will create these marks and only you can undo that. So just so we can have a smooth flow here, I will be in the chat. If you have any difficulties or have any questions, feel free to send them to me and I will get them to Daraine. Thank you.
Okay, so I believe that mark might have came from an iPad. Okay, all right, cool. We'll keep it moving. All right, so there's certain words we need to understand, like obligation versus alleged obligation. That's absolutely critical for us to understand because, as you saw, Congress just said the term debt means any obligation or alleged obligation. So you need to decide if it's going to be an obligation or an alleged obligation. That's absolutely critical to how things are going to turn out. Let's see. Hold on, we got 2 minutes. Okay. So obligation. Law or duty binding parties to perform their agreement. And that's taken from Black's Law Dictionary, 4th edition. Allegation, the assertion, declaration, or statement of a party to an action made in a pleading, setting out to what he expects to prove. So an allegation is something that is said or something that is insinuated without proof. There's no proof on it. They're alleging this. So that's why they need to prove it. The burden of proof isn't on you. The burden of proof is whoever is stating that you owe this alleged debt. So you have the right to decide if the debt is an obligation or an alleged obligation, and only you can do that. And remember, only the original creditor can validate a debt, and you are the original creditor. All right, so now we will pull up the law. This thing right here. Okay, cool. So I want y'all to write this down. So it's 15 USC 1692, right? And this is going to bring us to the Fair Debt Collection Practices Act. Now, once you're here, this is how the Fdcpa is broken down. And you're going to see it goes from A all the way to Q. So we always want to start with the congressional findings. And the reason why we want to start with the congressional findings is because we want to know what Congress found, why they put in these laws in place. All right, so let's go. Abusive practice. There is an abundant evidence. And for there to be evidence, that means an investigation must have taken place. There's an abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Abusive debt collection practices contribute to the #1 personal bankruptcies. So if anyone here has filed bankruptcy before, more than likely it came as a result of debt that's accumulating beyond your capacity to pay. To marital instability. I know a lot of people that got divorced for financial reasons. And most of the times, financial reasons are one of the biggest contributors to people getting divorces. To the loss of jobs and to the invasion of individual privacy. Now, I want y'all to take a pause for a minute and I want y'all to understand what this is saying. And to invasion of an individual privacy, meaning people coming into your life, getting your information without your permission. people are invading your privacy. So the intent of this is to make sure that you're able to protect yourself. This is consumer law, and consumer law was made to protect you. It's not made for corporations. The FDCPA speaks directly to the natural person, right? Which is the consumer.
Right.
All right. Say again, please.
Hey, we're not able to see, we can only see the PowerPoint. We don't see what you're seeing right now.
Oh, you're not. Okay,
Yeah.
let me fix that. Let me fix that. All right, stop screen, stop share. All right, let me see if I gotta do a new share. Okay, my bad. I thought it automatically did it. Y'all are able to see it now, right?
Yes, that's correct.
Okay, perfect. I thought when I switched from one thing to another, it would have just went, but obviously not. All right, Zoom needs to make an upgrade. We'll send that in as a feedback. So okay, so you should be at, make sure you're following with me too. If you have like multiple monitors. So we are at the congressional findings, which is 15 USC 1692, congressional findings and declaration of purpose. So now we just covered A, and we for the sake of just going over, I'll go over it again because y'all weren't seeing. There is an abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Abusive debt collection practices contribute to the number of personal bankruptcies, to marital instability, to the loss of jobs, and to the invasion of individual privacy. Now, this part here is key, and I don't want y'all to sleep on this. Individual privacy, which means someone has been invading your privacy. Hello. It's time for bed. Give me a kiss. Go to bed. Good night. Go to mama. Sorry about that.
Daraine, they're asking to share the case law you quoted before.
Which one?
Just like, I'm not sure. They just mentioned that in the chat.
No, it's not a case law. What I'm getting, it's not case law. This is actual federal law. It's not a case law. So if they type in 15 USC 1692, it's going to bring you to the Fair Debt Collection Practices Act, and this is where you'll find all the information. All right, so where were we? Yes, so we spoke about an individual privacy. Now, I want to show y'all something real quick as it pertains to an individual and privacy. You know what? That's on the PowerPoint. I'll get to that later on. Are you able to still see the screen? If they are, please let me know so I can continue.
Yes.
Perfect. All right. So basically, this is what happened. Inadequate laws, right? Inadequacy of laws. Existing laws and procedures for redressing these injuries are inadequate to protect the consumer. So the laws before the FDCPA, which is 15 USC 1692, it was inadequate and it was not protecting the consumers. So an investigation was done, and then this new law was put in place. Available non-abusive collection method. Means other than misrepresentation, which is what a lot of these debt collectors do. They misrepresent, right? Misrepresentation or other abusive debt collection practices are available for the effective collection of debt. Now, let's go down to D. Interstate commerce. Abusive debt collection practices are carried on a substantial extent in interstate commerce and through means and instrumentalities. Now, what does instrumentalities mean? Well, instrumentalities are different modes and ways that they use to either conduct business, whether it's by emails, the mails, sending someone, like anything that has to do with commerce. And instrumentality is being used because they have to communicate with you in some form of way or have some interaction, right? Even where abusive debt collection practices are purely intrastate. So interstate and intrastate, it doesn't matter. They were still doing it. Nevertheless, directly affected interstate commerce. So the purpose. So Congress now is going to tell us the purpose of the FDCPA. So out of everything that I just covered before, we're going to get to the reason why the FDCPA is in play. It is the purpose of this subchapter to eliminate I want you all to look at that word, eliminate. To eliminate abusive debt collection practices by debt collectors, to ensure that those debt collectors who refrain from using abusive debt collection practices are not completely disadvantaged, and to promote consistent state action to protect consumers against the debt collection abuses. So this was put in place to eliminate abusive debt collection and to make sure that consumers were not being abused. All right. So that's absolutely key. All right. 1 second, please. All right. So now we're going to go to definitions. Now, when it comes to any of the consumer laws, it is absolutely critical that you spend the time in the definitions, because if you don't understand the words that are being used, it's like sports. If you don't understand the rules of the game, you won't follow the game. So what definitions are the rules of how to play, because each word has their own individual meaning and they have multiple meanings and their individual action is different. So there's a couple different things we have to think about when it comes to the definitions, and it's absolutely critical that you understand. So you know how these credit bureaus call themselves bureaus? They're not no bureau. Under the Fdcpa, and not just the Fdcpa, the FCRA, which is the Fair Credit Reporting Act, the bureau is defined as one entity when it comes to consumer law. And that is, the term bureau means the Bureau of Consumer Financial Protection. That is the only bureau. So even though often we refer to Equifax, TransUnion, Experian, Nexus, SageStream, Innovis, ARS, LIC, as check system, as credit bureaus, they're really not. They're consumer reporting agency. That's it. They only report information. That's it. They are not known bureaus. Where were we? Okay. The term communication. Communication is absolutely critical that you understand that communication means the conveying of information regarding a debt directly or indirectly to any person through any medium. So Facebook is a medium, Instagram is a medium, LinkedIn is a medium, Snapchat is a medium, the USPS, United States Postal Service, is a medium, UPS is a medium. These are all mediums. It doesn't matter how they communicate with you. It's a medium. So as you can see, if you get an email or a DM from a debt collector on Facebook, they're really kind of not breaking the law. Yes, they are, but yes, they're not. And I'll explain later on. The term consumer means any natural person. So, consumer, any natural person. So when you see consumer, you're going to see at different points in the Fdcpa, the word consumer is going to come up. But at another time, you're going to see that consumer also means something else. So when the definition has changed, Congress is going to let you know when the definition has changed, right? So the term consumer means any natural person obligated or allegedly obligated to pay a debt. Wow. Any natural person. So Congress is really saying you have, so I have my drink or my pen. I can pick my drink or my pen, either or. You can choose. So if someone says, oh, you're the debtor, something like that, what type of profanity is that? Because we're going to see later on that when they talk about, oh, you're a borrower, you're a debtor, there is no such thing under the Fdcpa. So where do you get that foul language from? All right. Where were we? Number 4. The term creditor means any person who offers or extends credit, creating a debt, or to whom a debt is owed, but such term does not include any person to the extent that he receives an assignment or a transfer of debt in default solely for the purpose of facilitating collection of such debt for another. So basically what they're saying is this: a collections company or collection agency cannot be a creditor because they are in the business of an assignment which they got from the other company of purpose is to facilitate the collection of a debt. So it's a debt in default slowly for the purpose of facilitating the collection. So if you ever got anything from a collection agency where they're saying that they're the creditor, that right there is a violation and it's an automatic $1,000. I'll go into the $1,000 part later, and I'll also go in and show y'all how you can get more than $1,000 because $1,000 is nothing. Y'all can get so much more. All right, where were we? My favorite part. The term debt means any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property insurance, or services which are subject of the transaction are primarily for personal, family, or household purposes, whether or not such obligation has been reduced to a judgment. So Congress is saying it is an obligation, if you want it to be, or it's an alleged obligation. Which one do you want it to be? The one that you want it to be is how you will be addressed. Keep that in mind because the burden of proof is not on you. If they're writing that this is an attempt to collect a debt, they need to have proof to back up what they're saying. And we're going to go further down when we hit validation of debt of things that they think are validating a debt, but only the original creditor, which is you, the person who created the debt, can validate that debt. And I'm going to go into how they trick you. Well, you know what, since I'm here right now, let's go before I forget. So they'll send some deceptive forms and they'll say that, hey, we got this one-time offer, and let's say you had an alleged debt of $1,000, but for right now you can pay $200 and we will accept this payment, yada yada yada. Basically what they're using is a play upon words to trick you to make that first payment. Once you start making that payment, or once you made that payment, you just now validated their claim. So you just validated that debt by paying on it. You get what I'm saying? Because without your validation, that debt is invalid until it is validated. Only the original creditor can. You're the only one that has firsthand knowledge of this. So if you get that correspondence and you say, oh shit, it's mine, my signature is here, yada, 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 and you say, this is mine, you just validated that debt. That's why only the original creditor can validate that debt. But if you're saying, oh, hell no, this isn't mine, where y'all going with this nonsense? Guess what? They have to prove it. And nothing in the FDCPA, apart from the original creditor, it doesn't say whatever a collection agency throws at you validates a debt. Only the original creditor can. So let's go down to, oh, we're still at 6. No, yeah, we're at 6. So the term debt collector means any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the collection of any debts, right? Or who regularly collects or attempts to collect that directly or indirectly. Debts owed or due are asserted to be owed or due to another. So hold on. That first sentence just captured like 90% of everyone. So when they say, oh, I'm not a debt collector, don't lie to me, guy. Congress says you are. So now we're going to go down further in there, notwithstanding the exclusion provided by clause F of the last sentence of this paragraph, the term includes any creditor right? Who, in the process of collecting his own debts. So Congress is also telling you that creditors are indeed debt collectors as well. And you need to understand there's a difference between a creditor and an original creditor. Two different words mean two different things. In the process of collecting his own debts, uses any name other than his own, which indicate that a third person is collecting or attempting to collect such debt. So you'll have some companies, they'll have like a subsidiary company. They belong to the same company, but they operate under a different name in the attempts to collect the debt. That is all that is frequently used, and y'all got to be aware of that. For the purpose of section 1692F, 1692F6 of this title, such term also includes any person who uses any instrumentality of interstate commerce or the mails in any business. So as you can see, no business is excluded. So whether it's a government business, IRS, child support, or any other government business, Congress is saying to you, it doesn't matter the business, they are not excluded. Police departments, did any business, the principal purpose of which is to enforce, is the enforcement of security interests. The term does not include. Okay, so let's go down to here. Any officer or employee of a creditor while in the same name of the creditor collecting debts for such creditor. B, any person while acting as a debt collector for another person, both of whom are related by common ownership or affiliated by corporate control. Any officer, I'm not going to go through every single thing because I do want y'all to do some research. I'm going to highlight the main points. All right, let's go down to clause F because they did mention clause F. Any person collecting or attempting to collect any debt owed or due or asserted to be owed or due to another, to the extent such activity is incidental to the bona fide fiduciary obligation of a bona fide escrow agreement, concerns a debt which was originated by such person, concerns a debt which was not in default. Okay, so it's not in default at the time it was obtained by such person, or concerns a debt obtained by such person as a secured party in commercial credit transaction involving the creditor. Well, that was a lot of information, and some of this you definitely going to have to do some research on. All right, number 7, the term location information means a consumer's place of abode. I'm gonna pause here for a minute. I'm gonna take a drink. Pinky up, because this is something that y'all need to understand. Under the Fdcpa, the word resident is not included. So if you ever get any correspondence saying that, oh, we're looking for Jane Smith who resides or who's at the residence of 123 Main Street, I don't know who the hell that is, because as a consumer, I don't have a resident. A resident is for a citizen. A consumer has a place of abode. I'm going to say that again. A resident is for a citizen. You are not a citizen. Under the Fdcpa, you are a natural person, you're a consumer. A consumer's place of abode, not a consumer's place of residence. It used the word abode. So if you are addressed that your residence or your address or any of that nonsense is 123 Main Street, I have no clue what you're talking about, because as a consumer, under the Fdcpa, I have a place of abode. A place of abode. I do not have, I don't know why everybody chooses to call me when I'm busy. You have a place of abode. So that is absolutely key. So if you ever get anything, and like I said, they're asking you about a residence, an address, or any of that nonsense, They are not looking for you, they're looking for someone else because you are two persons. Let me see where it says that. I'm gonna show y'all something, creditor. Okay, so it's not defined here. All right, so most of you have heard this before. Your all caps name. Yes, it is real. Your all caps name is real. There's the corporation or organization, rather. That's the word Congress used. And you have the natural person, right? So if they're talking, the abode is for the consumer, the address is for your all caps name or whoever that citizen is. What you identify as really matters because this is how you're going to get this shit gone, right? So, you know how this is probably the only paragraph I've spent this much time because if y'all getting correspondence about an address, you don't have an address, you have a place of abode. Location information means a consumer's place of abode. So if someone calls asking about Jane Smith, who resides or is at the residence of 123 Main Street, Congress says you have a place of abode. So I don't know who they're looking for. If they are not using the words, it does not apply to you. They're talking to someone else. Number of such place or his place of employment. Okay. The term state means, and it's, yeah. All right. We're not worried about that one. Sheesh. All right. Now, y'all just saw that the FDCPA only has 8 definitions. Let me check my notes because I want to make sure that I wrote down some stuff that I didn't want y'all to forget. So, if you just saw, we went through the definition section, right? The term borrower was not included. I'm quite positive the word borrower was not defined. If this is a law about debt collection, why isn't the term borrower in there? I want y'all to think for me for a minute, all right? What is a loan? Oh, we're gonna get you a loan. Yay. Well, if you got me a loan, where in the definition section is the word loan? There's 8 definitions here, and I'm quite positive loan isn't one of them. So what type of foreign, so what type of language are you speaking to me? I don't see the word loan here. Be careful of words. Words are extremely powerful. Do not let any person or corporation call you or refer to you as something that you're not when the law is there to protect you, but you have to be able to speak the language. You are a consumer. You have a place of abode, right? There is no loan under the FDCPA. There is no borrower under the FDCPA. It does not address any of those. And if somebody calls you any of that, and this is no way, shape, or form legal advice, but if you're in court and anybody talk to you about, oh, you got this loan, oh, you're a borrower, oh, you did this, well, if the word regarding a debt collection, if the word is not defined under 15 USC 1692, 1692 A under the definition section, you don't know what you're talking about. It's obscene and profane language because I am very and highly offended. Mr. Whoever is representing, you called me a borrower. Where under the FDCPA does it define the term borrower? Because I am unaware that I am a borrower. I thought I'm a consumer. I know I am a consumer. Well, in fact, I know I'm the natural person. I know I'm a consumer. Why are you referring to me as a borrower? I have no idea what that language means. It is not defined under the Fair Debt Collection Practices Act. Why are you referring to me as a borrower? Why do you tell me that I got a loan? Like, what are you talking about? I don't know what you're talking about. What else? I want y'all to get into the habit of affidavits. Stop sending regular letters. get in when you're demanding stuff from them, get in the mindset of making affidavits. Why? Because an affidavit can only be rebutted by an affidavit, right? I have a little thing here that I want y'all to see. Where is it? All right. So I'm gonna stop share. All right, now I'm going to reshare. Share screen. All right, can everybody see the screen? I'm on YouTube.
Yes.
Perfect.
Instruments of tyranny. First is a gun, symbol of force, violence, and destruction. I'm going to show you two instruments of tyranny. First is a gun, symbol of force, violence, and destruction. This is not the best instrument of tyranny. This is the type of thing used by tyrants who are stupid, clumsy, and desperate. When the masses are being controlled by this,
Are y'all able to hear it?
Yes.
Okay, good, good.
can clearly we must destroy or escape whoever is pointing this at them. The smart tyrants use the other instrument of tyranny, paper. The paper on which is printed the auto registration you must show, the proof of insurance you must show, the tax form that you must file, the permit or license that you must pay for, the application you must fill out. Whether we realize it or not, we only submit to this because we are being threatened by this. What if we knew they did not have this? Would we do this? I wouldn't. When we do this, we are really reacting to this, tyranny. But just as a gun can be pointed in two directions, paper can be used by all parties. How can you use the power of paper? One way is something called an affidavit. An affidavit seems simple and harmless, simply a sworn statement of fact signed by a notary. But a lot more people have been robbed with this than with this. A properly executed affidavit is law until it is rebutted by another affidavit. Suppose you send your mortgage lender an affidavit that says, you just discovered that the loan documents they asked you to sign have misrepresentations, lack of disclosure, or fraud. If you are wrong, you may go to jail for perjury. If you're right, you may get the deed to your house free and clear. An affidavit is a powerful thing. The author of an affidavit can take all the marbles. He can make the rules. In my affidavit, I can say, you hereby agree to pay me $50 a month unless you rebut this affidavit within 30 days. If you make the mistake of tossing that affidavit into your inbox and forgetting about it, 30 days later, you are a slave to me. Under the law, $50 per month of your earnings belongs to me. That's the point of those cryptic notices from your credit card company. These are the new terms of your credit card. The law says that you agree and accept the presented terms unless you respond and refuse to accept. If you respond, you can change those rules all you want. All you have to do is respond. That notice they sent you is not enforcement of their rules. That is an opportunity for you to agree with their rules by remaining silent. Send a notice back saying, you may not charge me any late fees, and I will not pay more than 5% interest on my credit card charges. And those are the terms you must accept if you wish to have me as a credit card customer. If the credit card company does not rebut or cancel your card within your time limit, you are legally entitled to the terms you offer. Your announcements and demands are just as valid as theirs. If your notice is in the form of an affidavit, no judge, court, or officer may deny your claim, and the credit card company may not impose different terms unless you agree to them either by response or by silence. As odd as it seems, it's probably not a good idea to ever sign anything that you did not write yourself. If you write it, it benefits you. If they write it, it benefits them, and it probably costs you in a big way. An affidavit is not a complicated thing. Samples of them are easy to find. There's no particular layout that's required. Basically, it's a sworn statement of true and complete fact with a date and a notarized signature. If it affects another party, it must be presented to that party with a reasonable time for response. Large institutions are very good at sending notices, but they are not very good at reading and responding to notices they receive. That is not your problem. Institutional size and bureaucratic incompetence is not an excuse for anything. Send them the notice and hold them to the terms contained in that notice. If they refuse your terms, change the terms or walk away from the relationship. Just make sure that you always play by your rules, not theirs. That's what the Declaration of Independence is. Our rules, not theirs. Just as tyranny comes in many forms, revolutions come in many forms. We can have a nice nonviolent revolution. We can even do it all through the mail if we borrow a trick that institutions use against us. If this is used more effectively, then nobody will have to do this. But don't do it if you don't know what you're doing. Paper can be dangerous. I'm Jerry Day, and this is Matrix.
All right, so the power of paper is an absolutely powerful thing. And y'all need to understand that paper is very, very dangerous. So you have to be careful how you use it. So now that we're on the topic of affidavits, what I'm going to do is I am going to pull up what an affidavit is. All right. Shares, new share. So an affidavit is a written statement confirmed by oath or affirmation for the use as evidence in court. I'm gonna read that again. A written statement confirmed by oath or affirmation for the use of evidence in court. Now, let's go a little bit further. That. All right, here we are. Are you still able to see the screen? Yes? Yes, no, yes, somebody?
Yes.
Okay,
Yes,
cool.
I can see it.
So
Yes,
you,
that's it.
all right, so you're seeing 28 USC 1746. Are you seeing that?
Yes.
Perfect. All right. Let me get this thing out of the way. Let's put it back up here. So basically, this is unsworn declarations under penalty of perjury. This is what given affidavits so much power, right? So it's 28 USC 1746. Write this down and you can go revisit it later. But what I want to get to is this. Wherever under any law of the United States or under any rule, regulation, order, or requirement made pursuant to law, any matter is required or permitted to be supported, evidence, established, or proved by the sworn declaration, verification, certificate, statement, oath, or affidavit in writing of the person making the same, other than a disposition or an oath of office, yada, yada, yada. Such matter may with like force and effect be supported, evidence established or proved by the unsworn declaration. Right, basically it repeated itself. What I want to get to is this. Number two, one is if you are without the United States, but number two, well, most of us are in the US, if not all of us right now, are in the US. And basically, this is what gives you your power. If executed within the United States, its territories, possessions, commonwealths, I declare or certify, verify, or state, whichever one you want to use, under penalty of perjury, that the foregoing is true and correct, executed on this date, and your signature. And this is where you get that notary to sign that you just swore an oath verifying that all the information that you provided in this affidavit is true. This is what gives it its power. All right. So I just wanted y'all to get a peek at where it speaks on what gives the affidavit its power. All right, now let's get back to the FDCPA. Move this back up here. All right, acquisition of location information. Any debt collector communicating with any person other than the consumer for the purpose of acquiring location information. And you remember when we spoke about location information, what does location information mean? The term location information means a consumer's place of abode, not your address, not your residence, your place of abode. So if they're not talking to you about your place of abode and they're talking about some residence or some address, you have no idea what you're talking about because you, the consumer, don't have an address. You don't have a residence. You have a place of abode and his telephone number at such place or his employment. All right, so just wanted to make that clear. About the consumer shall. So let me read this over. A debt collector communicating with any person other than the consumer for the purpose of acquiring location information about the consumer shall. Now this word here, it doesn't, they don't have a choice. There's no choice given here. There's absolutely no choice given here. What they are saying is this: they shall comply. There is no if, no buts, or maybe, right? So they shall identify himself, state that he is confirming or correcting location information. So let's go back. State that he is confirming. So they shouldn't be asking you if you live at 123 Main Street. They should already come prepared with that information, right? So you got to understand the words that are being used or correcting it. So they should be either confirming or correcting, not asking you where this person is. If they do, that off the rip is a violation, right? So that's $1,000 already. Location information concerning the consumer and only if expressly requested identifies the employer. So a lot of people think that because they call you, they have to tell you who they are and I mean who they're working for. They're supposed to identify themselves, but as it pertains to their employer, you have to ask. The consumer got to ask. Because if you don't ask, they don't have to tell you that part. And I didn't make that up. The law says it. Number two, for those of you who've ever gotten a call or any correspondence in the mail or email or whatever, it's going to say this is an attempt to collect the debt and any information gathered, that mini Miranda, right? Well, what does number two say? Congress says they shall. Number two says not state that such consumer owes any debt. So they're not supposed to be telling anybody that this is an attempt to collect the debt because right there you're telling that the consumer owes a debt. Well, if the law says you're not supposed to do it, you're breaking the law. That's $1,000 again. So we're at like 2,000 right now. Number three, not communicate with any such person more than once, unless requested to do so by such person, or unless the debt collector reasonably believes that the earlier response of such person is erroneous or incomplete and that such person now has correct or complete location information. So if you told them everything you knew, they should be only contacting you one time. Now, if they do believe that the information that you gave them was sketchy, under this portion of the law, they can contact you again. Not communicate by postcard. How many people I wish I should have had it. A postcard. So they're not supposed to send you a postcard. No debt collector shall communicate by a postcard. None. You shouldn't be getting any postcard because there's so many hands that touch that postcard. This is basically them saying, hey, John Doe owes us a debt, or John Doe has a debt that we are attempting to collect. They're not supposed to do that, right? That's a invasion of your individual privacy, as Congress stated before. This is the reason why we're having so many bankruptcies, so many marital instability, is because your your individual privacy is being invaded. Like you are being abused, and it's time you take the power back. Number 5, not use any language. Hold on, hold on, hold on, hold on, hold on. Pinky up. Because this part right here, this part right here, this part right here. Okay. Not use any language. I'm going to go very slow. Please write this down. Not use any language or symbol or any envelope or in the contents. So there's nothing supposed to be on the envelope, no language, no symbol, or nothing inside the contents of that envelope of any communication effected by the mails or telegram that indicates that the debt collector is in the debt collection business, or that the communication relates to the collection of a debt. Now, wait a minute. Hold on, wait a minute. Let me take a sip of my Appleton. Whew. I really have to pause for a minute because Congress is saying they shall not use any language. Remember, Congress didn't define what language is. What does language mean to you? Okay. Or symbol. What does symbol means to you? Right? So a logo is a symbol. The language, if they say capital 1, that's a logo, and that language indicates that, well, they're in the business of debt collection. I'm just saying. I didn't say it. Congress did, right? Where are we? So after a debt collector knows that the consumer is represented by an attorney with regard to the subject debt, and has knowledge of or can readily discern such attorney's name and address, not communicate with any person other than that attorney, unless the attorney fails to respond within a reasonable period of time to communicate from the debt collector. So basically what they're saying is, if you have an attorney, they should contact your attorney. However, if they do attempt to contact your attorney and your attorney fails to respond within a reasonable amount of time, they can contact you. All righty. Let's get you in here. Communication. This is a very, very important and very big topic. So let's go. Communication with the consumer generally, right? So right now, the communication section is 15 USC 1692C. And remember, I told y'all that there isn't, well, I haven't read it. So if someone has, please let me know. There's not a law that says you have to pay a debt, but there's a law that says you can refuse to pay a debt. It's in the communication section, and we're going to get there. So please pay utmost attention right now. Without the prior whoa. Well, I think I'm seeing doubles. Where's my glasses? Without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction, a debt collector may not communicate with a consumer in the connection with the collection of any debt. Hold on, Daraine. What are you saying to me? I'm saying I didn't say it. What did Congress say? I'm think I'm reading this right, because Congress is saying without the prior consent. So the consumer needs to give the debt collector consent for the debt collector to communicate with the consumer. Daraine, I don't know what you're talking about. What are you talking about? Okay. Without the prior consent of the consumer given directly to the debt collector or the express permission of a court. Okay, Daraine, so I think you're saying if I don't give them permission and a court doesn't give them permission, they shouldn't be talking to me. Is that what you're saying? It's not what I'm saying. I think that's what Congress just said because we all just read it, right? So let's see. At any unusual time or place, or a time or place known or which should be known to be inconvenient to the consumer. Well, hell, any time for me is an inconvenience time. So I don't know about you, but excuse me, anytime a debt collector tries to get some money from me, that's an inconvenient time. That's $1,000 right there. Excuse me. So let's go. In the absence of knowledge of circumstances to the contrary, a debt collector shall assume that the convenient time for communicating with a consumer is after 8 o'clock a meridian, that's AM, and before 9 o'clock post meridian, that's PM, local time at the consumer's location. Well, hold on, Daraine. What are you talking about? Congress is saying at any unusual time or place to be known or which should be known to be inconvenient to the consumer. You decide what is inconvenient for you, right? Any violation of that is $1,000. But you know, when they say, oh, a debt collector has the right to contact you after 8 a.m. and before 9 p.m., well, that's a fucking lie. What are you talking about? A debt collector can only assume in the absence of knowledge of circumstance. They can only assume. So when you don't respond, then they can assume that they can contact you between 8 a.m. and 9 p.m. But if you make it known that it's inconvenient for them to contact you, it is a violation if they attempt to contact you. That's what Congress is saying. Let's move on to number 2. If the debt collector knows that the consumer is represented by an attorney, we went through this before, so I'm gonna skip over this one. At the consumer's place of employment, if the debt collector knows or has reason to know that the consumer's employer prohibits the consumer from receiving such phone calls. Well, I need to talk with my boss because I want to know, when did he have a conversation with XYZ collections company that it was okay to contact me? But if I'm self-employed, my employer, which is me because I work for me, I'm doing this Zoom right now. If a debt collector calls me on my cell phone while I'm in this Zoom, well, this is a very inconvenient time to contact me. You just violated me under the Fdcpa, and I'm gonna go get you for my $1,000. It's inconvenient. I'm self-employed. You didn't communicate with the employer. The employer doesn't want you to contact me during working hours. That's a violation. Now, remember earlier I said that there's a law that gives you the right to refuse to pay a debt? Well, here we are. It is ceasing communication. So we're at 15 USC 1692 CC, ceasing communication if a consumer notifies a debt collector in writing that the consumer refuses to pay a debt. Hold on, Daraine. Hold on. What did Congress just say? If a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication. We all know what communication means. If not, please go back to the definition section on your own time and revisit what communication means. With the consumer, the debt collector shall not communicate further with the consumer with respect to such debt, except, all right, what are you saying? To advise the consumer that the debt collector's further efforts are being terminated. Okay. To notify the consumer that the debt collector or creditor may invoke specified remedies which are ordinarily invoked by such debt collector or creditor. Well, it's a two-way street, because whatever they can do, you can do as well. So you can invoke your own specified remedies on a debt collector for violating you under the Fdcpa. This isn't a one-way street. It's a two-way street. Whatever they can do, you can do, but more. So let's get into it. If such notice from the consumer is made by mail, where is it? Okay. If such notice from the consumer is made by mail, notification shall be complete upon receipt. And this is why I keep saying send everything certified mail, green return receipt. This completes your notice. I didn't say it, Congress did. Certified mail, green return receipt. If such notice from the consumer is made by mail, notification shall be complete upon receipt. Certified mail, green return receipt. Consumer. So remember earlier, I told you that Congress had two different definitions for consumer under the Fdcpa. Well, this is the second definition. For the purpose of this section, the term consumer includes the consumer's spouse, parent, if the consumer is a minor, guardian, executor, or administrator. Well, it's a lot of words here. So the word consumer under communications. So in respect to the communication section, the term consumer includes the consumer, which is a natural person, your spouse, your parent, a minor, if the consumer is a minor, guardian, executor, or administrator. So if a debt collector is calling any of those individuals listed, and they're violating any section hereof, it is a violation, and you gotta get up to speed on these things. All right, let's go back. We're finished with communication. Harassment or abuse. Wow. Okay. Let me go a little faster because I don't want to keep y'all here all night. But this thing is so good. Like when y'all get this, man, this is why I be up studying all night. Like harassment or abuse. So I'm gonna speed it up a little bit. All right. A debt collector may not engage in any conduct, the natural consequence of which is to harass, oppress, or abuse any person in connection with the collection of a debt without limiting the general application of the foregoing, the following conduct is a violation of this section. Number one, the use or threat or use of violence, threat, the use of threat, of use of violence, or criminal or other criminal means to harm the physical person, the reputation. Whoa, well, under the FCRA, when Congress gives the definition for consumer report, your consumer report is your reputation. So if you are threatened by a debt collector that they're going to put something on your consumer report which is damaging to your reputation, it is a violation of this section and you are owed $1,000. Or property of any person. That's why it's important that you study the laws, because the laws run parallel, but they are all connected. So someone says they're going to throw it on your consumer report regarding the debt, it is a violation, it's $1,000. The use of obscene or profane language, or language the natural consequence of which is to abuse the hearer or reader. I can't define what obscene and profane language is to you. If you discern what they're saying is obscene and profane, then it is a violation under this section. You're owed another $1,000. That's why it's important that you keep all the letters and you go through all of them. The publication of a list, what? The publication of a list of consumers who allegedly refuse to pay debts except to a consumer reporting agency or to persons meeting the requirements of section 1681 AF or 1681B3 of this title. So 1681 and 1683B, well, shit, let's see what that's talking about. 1681, or is it F? So which is a consumer reporting agency, right? So they're talking to a consumer reporting agency. Let's get that out of the way. 1681B3, who is that referring to? 1681B3, to a person in which it has reason to believe. Well, that doesn't tell me much. Intends the use of information connecting a credit transaction involving a consumer on whom the information is furnished and involving the extension of credit. All right. Well, I don't see any court in this. So for those of you who've ever had, if you go to the courthouse and you see a list of names of people that their property is being foreclosed on or that's going up for auction or sheriff's sale or whatever you call it, under the Fdcpa, the publication of a list of consumers who allegedly refuses to pay debt is a violation under the Fdcpa. So if you're going up for foreclosures, short sales, and you are being publicized, whether the bank that did an REO, a real estate own, and they gave it to a realtor and they put it on even the MLS, that is a publication because it lists REO, real estate own. It's a publication that the person who owned this cannot pay the debt. So that in itself is a publication as well. Or it's an advertisement for sale to coerce payment of the debt. So the advertising of the debt, oh, we're going to have an auction on July 5th. Well, that's an advertisement of a publication of a list of consumers who allegedly refuse to pay their debts. So those in itself is a violation. So even repossessions, because you go to an auction, it's an advertisement for sale to coerce the payment of a debt. So repossession is actually a violation of the Fdcpa. Follow me here. Causing a telephone to ring or engaging any person in telephone conversation repeatedly or continuously with intent to annoy, abuse, or harass any person at the called number. Now, if your phone rings, you don't even have to answer it. If your phone rings and you discern that the intention is to harass, abuse, annoy, guess what? You're owed a violation. But that's just the FDCPA, because if we go to the TCPA, let's put this up here. I want y'all to see it real quick because I want y'all to look it up. I'm not going to go into details, but I want y'all to Google Telephone Consumer Protection Act. Save it in a browser, whatever you need to do. 47 USC 227 section 227. Save it in a browser, whatever you need to do, but you need to go revisit this, right? Put this up here. Private right of action. Get that, bro. Okay. A person or entity may, if otherwise permitted by the laws or rules of court of state, bring in an appropriate court of that state an action based on a violation of this subsection or the regulation prescribed under this subsection to enjoin such violation. An action to recover or actual monetary loss for such a violation, or to receive 500 in damages for each such violation. So this is violation under the TCPA. I want y'all to look it up when read through it. But number 3 is where they're going to talk about remedies, right? Whichever is greater. If the courts find, so if they keep calling you after you say, please stop calling me, or you send a cease and desist, but they still call you, keep your log, your cell phone log, right? What you're going to do, you're going to print out your call history, and you're going to identify, highlight, mark, whatever you want to do, mark that shit up, and you're able to present it in a court. And listen what this is saying. If the court finds the defendant willfully or knowingly violated this subsection. So after you tell them to stop calling you, now we're under the TCPA. So y'all got to read through that one. Like, we're not going to finish if I go through it in depth. Willfully or knowingly violated this section or the regulation prescribed under this subsection, the court may, in its discretion, increase the amount of the award to an amount equal to not more than 3 times the amount available under subparagraph B. B says 500 per violation, but if you're able to bring that printout with you and you're able to show that you had sent in a cease and desist, or you recorded the call and you stated that you told them to stop calling you, but they still called, they still annoyed, they still harassed you, well, you can get up to $1,500 per call. All right, so I'm gonna just leave that one there. So, all right, let me get out of it. All right, think we're done with this one. False or misleading representation. All right, we're gonna get out of this one real quick. I'm gonna hit the major points and then we're gonna get out of it. False or misleading representation. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt without limiting the general application of the foregoing. The following conduct is a violation of this section. The false representation or implication that the debt collector is vouched for, bonded by, or affiliated with the United States or any state, including the use of any badge, uniform, or facsimile thereof. Well, Mr. Officer, who pulled me over with a badge that gave me a ticket, that had me go to court, guess what? You are in violation of the FDCPA, because what the ticket is, isn't the ticket that sends you to court is an attempt to collect the debt. Any person. It didn't specify and say that, certain person. It says any person. So you got to be able to think, isn't that ticket an attempt to collect the debt. All right. The false representation, the false representation of, this is very important, the character, the amount, or legal status of any debt. Now, if you're familiar with double entry bookkeeping, there is assets and liabilities, positive and negative. If it's in positive balance, it's positive. If it's in negative, you owe it, right? Generally accepted accounting principles. So if they're saying that this balance is in a positive amount, how is that a bill? How is that a debt? If it's in the positive amount, like, follow where I'm going with this. So that is why I want y'all to visit 15 USC 1666, correction of billing error. Because if they're saying that you owe this bill, why is it in a positive balance? If you owe something, it's negative, right? Just like when you overdraft, meaning you use funds that is not yours. You owe the bank whatever that negative amount is. When you pay it back, it goes to zero, and then everything forward is in a positive balance because you now have that in there that is yours. So if you're sending me a bill or a statement, I think this is a billing error. And this is where you can get them for $1,000 under this section. All right. Where were we? Oh, we're still here. Let's go back to the other one. Any services rendered are compensation for which may be lawfully received by any debt collector for the collection of a debt. Right, that's not really important. This is what's important. So remember when I told y'all that a lawyer has no business in a court with any debt collection attempts. Any debt collection attempts, a lawyer should not be involved. This is where Congress tells you that lawyers are fraudsters and they should not be in the court. The false representation or implication that any individual is an attorney or that any communication is from an attorney. An attorney cannot be a debt collector, and a debt collector cannot be an attorney. Congress just told you that no individual, any individual that is an attorney should not be sending you any correspondence regarding to the collection of any debt, because it is the following conduct. We are judging conduct is a violation of this section. So Congress is telling you that this is a violation of this section if you get anything, any communication from an attorney. It is absolutely bogus. It is absolutely breaking the law. You just saw it. I'm not making the shit up. Congress told you you shouldn't be getting any correspondence, any type of communication. And we know what communication is because you're going to go back to the communication section and you're going to read what communication is. The representation or implication that non-payment of any debt will result in the arrest or imprisonment of any person or the seizure, garnishment, attach or sale of any property or wages of any person unless such action is lawful, and the debt collector or creditor intends to take such action. Well, if anybody's in these streets telling you that they're going to do something they're not permitted to do, someone just violated you. So if they say, "Oh, we're going to send you to jail," well, what law says I have to pay any bill? I can show you the law that says I can refuse to pay it. So how are you going to send me to jail? So now you're making threats on accusations on things that you cannot do. It is a violation of this section. The threat to take any action that cannot be, so they use the word legally here and lawful up here. Why not the same words? Why not the same words? Oh, all right, let's go. The threat to take any action that cannot legally be taken or that is not intended to be taken. Well, we know that a debt collector has no legal right. So Congress is telling you they cannot take any legal action because they have no legal right. So it's smoke and mirrors, people. I'm gonna show y'all where Congress says they have no legal right. The false representation or implication that a sale, referral, or other transfer of any interest in the debt, in a debt shall cause the consumer to lose any claim or defense payment, become subject to the, okay. The false representation or implication that the consumer committed any crime or conduct, all right, communicating the threat, all right, these are all important points, but here we go. Number 11. All right. Please, please, please write this down. 15 USC 1692 E. Number 11. Now, don't forget, 3 is absolutely important. Absolutely important. But I'm gonna show y'all where I'm getting at real quick with this. The failure to disclose in the initial written communication with the consumer, and in addition, if the initial communication with the consumer is oral, in that the initial communication that the debt collector is attempting to collect a debt and that any information obtained will be used for that purpose, and the failure to disclose in subsequent communications that the communication is from a debt collector, except that this paragraph shall not apply to a formal pleading made in connection with a legal action. Whoa, Daraine, what the hell did you just say? Didn't you say earlier that if they contacted me, that they were supposed to say that they're a debt collector? All right. Let's look at something real quick. So, can y'all still see the screen? I just switched screen and I want to make sure that y'all can still see it. Can y'all still see it? Yay, nay.
Yes.
Perfect. You're seeing the PowerPoint, right? That's what I should have asked. You're seeing the PowerPoint.
No.
No.
Okay,
Just legal information.
that's what I need to see now. I need y'all to see this PowerPoint real quick. Damn, somebody's marking up the screen. Shit. All right. I hope y'all can still see this. Can y'all see it?
Yeah.
Please
Yes.
do not do the swiping on the screen. It's doing a thing. And yeah, please, 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 please. Okay. All right. So we're going to deep dive for a minute. 15 USC 1692 B5. No, please write this down. Please write this down. So we're looking at 15 U. Y'all keep moving that thing. It's marking the screen up. I don't know how Zoom take that out, but until I figure it out, please refrain from the marking. Like, get a notepad, please. Because before we know what the screen's gonna look like, it's a 3-year-old trying to learn ABCs. 15 USC 1692 B5 versus 15 USC 1692 E11. Now, these two might sound contradicting, but they are not, and I'm going to tell you why. So, 15 USC 1692 B5, acquisition of location information, it's under that section. It says, not use any language or symbol or any envelope in the contents of a communication effected by the mails or telegram that indicates that the debt collector is in the debt collection business or that the communication relates to the collection of any debt. Wow. Well, Daraine, you just said that they're supposed to say it, but you just said that they're not supposed to say it. So guess what Congress is saying? Under false and misleading representation, The failure to disclose in the initial written communication with the consumer and in any addition, if the initial communication with the consumer is oral, in that the oral communication that the debt collector is attempting to collect a debt and that any information obtained will be used for that purpose, and the failure to disclose in subsequent communication that the communication is from a debt collector, except that this paragraph shall not apply to formal pleading. Now, if they say this is an attempt to collect a debt, it's a violation. If they don't say it, it's still a violation. So what I'm getting at is whether they say it or not, it is still a violation. And a violation, on any violation under the Fdcpa, you are owed $1,000. Whether they say it or whether they don't. I didn't make this shit up. Congress said it. Please write down 15 USC 1692B5 and write down 15 USC 1692E11. I didn't make it up. I promise I didn't make it up. All right. Stop share. I'm going to go back to. All right. Where is the thingy? Shit. I think I might have lost it. All right. Here we go. Share screen. Okay. Back here. Boom. All right. Can you all see Legal Information Institute? Are we back on track?
Yes.
Perfect. All right. So we just finished with 11. The false representation or implication that accounts have been turned over to innocent purchasers. All right. The rest of this, you can go through it. It's important, but it's not that important at the moment. But please make sure that you go over it in its entirety. Because if we do every single thing, I promise we will not leave here tonight. But if y'all are down to party with me, I'll go through every single thing. All right. So we just finished false and misleading representation. Let's go to unfair practices. All right. A debt collector may not use unfair or unconscionable means to collect or attempt to collect any debt without limiting the general application of the foregoing. The following conduct is a violation of this section. The collection of any amount, including, listen, the following conduct is a violation of this section. So everything that I'm going to read here is a violation. So if that has happened to you, please make a note of it. The collection of any amount, including any interest, fee, or expense incidental to the principal obligation, unless such amount is expressly authorized by the agreement creating the debt or permitted by law. So if they exaggerate an amount more than what it is, if the law doesn't permit that, or you went into some expressed authorized agreement that created this debt, it is a violation for them to inflate the said amount. The acceptance by a debt collector from any person of a check or other payment instrument post-dated more than 5 days unless such person is notified in writing of the debt collector's intent to deposit such check or instrument not more than 10, not less than 3 business days prior to such deposit. The solicitation by a debt collector of any post-dated check or other more briefs to this. This one y'all can go through on your own time. There's not much major key points here. The using any language or symbol other than okay, 8. Let's not skip over 8. So unfair practices, right? There's a reason why I keep going back to the topic. Number 8 says using, before I go to number 8, what did Congress say? The following conduct is a violation of this section. Number 8 says, using any language or symbol other than the debt collector's address. The only thing that should be on the envelope is the address. If there's a logo, a name, anything that's there, it is a violation. That's $1,000. Keep all your envelopes. Keep them all. On any envelope when communicating with the consumer by use of mails or telegrams, except that a debt collector may use his business name if such name does not include that he's in the debt collection business. Really? Well, that's going to be hard because guess what? Their name says that you're in the debt collection business and they cannot use any language or symbol. So you have to identify those, circle it, mark it, $1,000. For every violation that you find that is in your correspondence, it is $1,000 under the Fdcpa, $1,000. All right, so let's get out of this one. Here we are. Validation of debt. Sheesh. Hope, take a drink. Y'all take a drink, because this, take a drink. Just take a drink. All right. When you get correspondence in the mail from a debt collector saying this is an attempt to collect a debt, we know that's a violation already, right? There's a few things that must happen. Within 5 days after the initial communication, the first time that debt collector ever made contact with you, with a consumer in connection with the collection of any debt, a debt collector shall, it's not a choice, it's not an option, they shall, unless the following information is contained in the initial communication, or the consumer has paid the debt, send the consumer a written notice containing. Please read this paragraph. Know this paragraph like the back of your hand. 15 USC 1692G, validation of debt. Please let this be your mantra. All right? There are 5 things that the initial communication must have. If any of these things are missing, right? So let's talk about what the things are and then if they're missing, right? Congress is saying within the first 5 days of communication, they must send you all of this, right? So number 1 has the amount of the debt. How much is it? The name of the creditor to whom the debt is owed. Well, y'all notice they use creditor and not original creditor because we all know who the original creditor is, right? Okay. A statement that unless the consumer within 30 days of 30 days after receipt of the notice disputes the validity of the debt or any portion thereof, the debt will be assumed to be valid by the debt collector. When they send you all these notices, you gotta respond. Stop throwing it away and think that if I don't think about it, it's not gonna happen. No, it is gonna happen, because if you don't respond, a debt collector can assume the debt to be valid. They can. A statement that if the consumer notifies the debt collector in writing within 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt or a copy of a judgment against the consumer and a copy of such verification of a judgment that will be mailed to the consumer by the debt collector. Really, Daraine, what are you saying to me? Hold on, there's more. A statement that upon the consumer's written request within 30-day period, the debt collector will provide the consumer with the name and address of the, what is this, original creditor. But didn't they say creditor up here? So now we're talking about an original creditor. All right. Know the difference. If different from the current creditor. Now, Congress is saying the first communication, they must present you with all of this, everything. They shall. It's not a think or a I will later on, or no. First communication or within the first 5 days of the initial communication. Y'all gotta hold them to this timeline. If they don't give you all of this in the first communication, within 5 days of the first communication, all of this must be presented to you. If it's not presented for each action, it is $1,000. So let's say they only gave you the amount of the debt, but everything else is missing. It's $1,000 per violation. So I hope y'all are seeing where I'm going with this. I can give y'all the information, but you have to be the one to really enforce your remedy. And I hope y'all are keeping track of the amount of money you can really get from this shit. Every violation under the Fdcpa is $1,000. So, but wait, there's a second part to this, right? Because Congress says they shall. So we just did the shall part. Let's move to the unless now. Well, if you don't get all of this from them in the initial correspondence, it could simply mean that the consumer has paid the debt. And if there was a finance charge involved, we all know, according to 15 USC, please write this down. 15 USC 1605. It's going to bring you to the Truth in Lending Act, and it's going to explain to you what a finance charge is. And we know that a finance charge is the sum of all charges. Sum means everything. Everything, everything. That's what sum means. So if the debt's already paid for, because they send it to you in a positive balance, they don't have to provide you with all of this. Just saying. Now, let's go down to disputed debts. Oh, I got something that I want y'all to see too. Hold up, wait a minute. Y'all thought I was finished? All right, I'm gonna stop share. I'm going to reshare. I hope everybody's looking at the screen. All right, can everybody see the screen? Yes, yes, yes.
Yes.
Drop a lot in
Yes,
the chat
yes,
if you
yes.
can see
Okay.
the screen.
Y'all are seeing the PowerPoint, right?
Yes.
Okay, so for right here, I want everybody to unmute. Everybody unmute. Don't speak yet, just unmute. Everybody unmute. Don't speak. All right. I want you to say this. Say it.
I am
the original creditor. Only I
I
can.
can validate
validate
this
alleged debt.
All right. So say it with me. I
I
am
am
the original creditor.
original creditor.
Validating alleged debt.
Only I
Only
can
I
validate.
I can
validate this alleged debt.
All right. So we're gonna do it one more time, but wait. You're gonna say it with me, all right? So we're gonna do line by line by line. All right, let's do this. We must get this shit right.
Countdown.
So we're gonna start in 3, 2, 1. I
I am
am
the
the
original creditor.
original creditor.
Only
I
I
validate the debt.
All right, y'all got it. Y'all got it. Every time y'all go to the mirror, make sure y'all say this. Now, y'all can go back on mute. All y'all go back on mute. All right, we had to do that. All right. So let's let's talk about what validation means real quick. So we need to understand the difference between validation and verification, right? All right. I think someone's still on unmute. Please mute. Okay, thank you. All right. So validation, the action of checking or providing the validity or accuracy of something. So you are assessing. So when Congress says they need to provide you all of these 5 things for validation of debt, it doesn't mean that when they provide all of it, it validates the debt. That's not what it means. You are checking the validity and the accuracy of the information being presented to you. Excuse me. Congress then says you can even go further and request verification. Well, verification is the process of establishing the truth, accuracy, or validity of something. So, based on what they told you, right, you now must decide, is this an obligation or is this an alleged obligation? Only the original creditor, which is you, can decide that. This is where you assess the action. And remember, not because they provided you a contract, not because they provided you a goddamn contract with your signature on it, it doesn't validate shit because Congress just said that they're supposed to give you this. It doesn't say that them producing it validates the debt. It does not. So you gotta understand. I think somebody is still not muted. If you can go back on mute, please, that would really help. Thank you. New share. Okay, here we go. So now we're gonna go back to this. So when you dispute a debt, when they send you something saying that, hey, you owe this. Nope, 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 nope. Wait a minute, guy. Wait a minute. What are you talking about? I got no business with you. What are you talking about? You know what? 15 USC 1692 G, validation of debt. And for everyone that's here tonight, you will get my validation of debt letter. Very powerful. Just wait until we go into that. That's gonna be the last thing we're gonna go into. Like y'all gonna see, man, this shit is crazy. If the consumer notifies a debt collector in writing within 30-day period described in Section A that the debt or any portion thereof is disputed, or that the consumer requests the name and address of the original creditor, the debt collector shall cease communication of the debt. Well, cease collection, I'm sorry. Cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or a copy of a judgment or the name and address of the original creditor and a copy of such verification or judgment or name and address of the original creditor is mailed to the consumer by the debt collector. Well, when you hit them with a cease and desist, a validation of debt, all collection activity must stop. It means reporting to the consumer reporting agencies. That's a form of debt collection. Sending you bills saying that you need to pay, calling you. All of this is an attempt to collect a debt. And what this is saying is once you dispute the whole debt or any portion thereof, all collection activity must stop. So if someone is trying to send you a repo, if they're saying, oh, we're gonna repo your vehicle, and okay, I'm gonna hit you with a debt validation letter. Let's go. I'm gonna send it in affidavit format too, so you can only rebut it with an affidavit, because we know that an affidavit stands as truth in commerce after 30 days if it's not rebutted by an affidavit line for line. Make the shit difficult. Don't just be writing letters. Make the shit difficult. All right. Collection activities and communications that do not otherwise violate the subchapter may continue during the 30-day period referred to in subsection A unless the consumer has notified the debt collector in writing that the debt or any portion of the debt is disputed, or that the consumer requests the name and address. So basically, if you say you want everything, give me everything, and I'm disputing the debt, I need validation, I need verification, I need the original creditor, every single thing, they have to stop all attempts to collect a debt. Everything. And I've heard a lot of people express to me that either them or someone they knew, because they didn't show up to court, there was a default judgment. I want y'all to listen real quick and make sure that y'all write this down. Congress said this, I didn't make it up. Admission of liability. The failure of a consumer to dispute the validity of a debt under this section may not be construed by any court. It doesn't matter the court. Congress says no court shall use this as an admission of liability on the consumer if the consumer fails to dispute the validity of a debt. So for child support, if you know people that are locked up right now and they have their whatever they're earning in there being garnished by these fucking crooks because they weren't able to show up in court, how are they going to show up in court if they're fucking locked up? But yet there was a default judgment. Now, I'm not advocating for a person not taking care of their child, but if you made them in private, take care of them in private, like everybody's grown, handle your responsibilities. So a default judgment is illegal. There should be no default judgment as it pertains to any attempts to collect a debt. And Congress just said the failure of a consumer to dispute the validity of a debt under this section may not be construed by any court as an admission of liability by the consumer. I really hope y'all wrote that down. And this is 15 USC 1692 G C, admission of liability. Now, for some people, especially this week, I heard of a lot of stories of people receiving correspondence, and the initial correspondence was for them to show up to court. There was nothing before that. The first communication, well, let's see what Congress has to say. And remember that where is it? We're assessing actions and we're talking about violations. So a communication in the form of a formal pleading in a civil action shall not be treated as an initial communication for the purposes of this subsection. So if the first thing you ever got was a summons or something of that nature for you to go to court under the Fdcpa, that is a violation and it is not supposed to be treated as initial communication. There's a process where you have to get something where you're able to request validation within a 30-day period. They're supposed to give you certain items. The first communication should not be about you appearing to any court. So if that ever comes up this is the section that you're going to use to shut that shit down. The sending or delivery of any form or notices which does not relate to the collection of a debt and is expressly required by Title 26, Title 5 of the Graham-Leach-Bailey Act, or any portion of the federal state law relating to the notice of data security breach or privacy, or any regulation prescribed under such provision of law shall not be treated as an initial communication in connection with the debt collection for the purpose of this section. So please read more into this. But Congress gives you the right, not because they say, oh, Mr. John Smith, you owe this debt, it means you owe anything. Not because they gave you some statements or some contract, because the word contract isn't even defined under the FDCPA. Like, what is a contract? I don't know. Like, these are obscene and profane language. So y'all need to understand that you need to know this law. Like, you need to know it like the back of your hand, all right? All right, we did that. All right, multiple debts. If any consumer owes multiple debts and make any single payment to any debt collector, with respect to such debt collector may not apply such payment to any debt which is disputed by the consumer, and where applicable, shall apply such payment in accordance with the consumer's direction. Now, this might sound gibberish to a lot of people, but let's say your car note, and you disputed the debt. And remember, when you dispute a debt or you hit them for validation, all collection activities must stop. And Congress is saying, if you dispute the debt, the consumer has the right to direct where such payment goes or all subsequent payment. So if you discharge the debt and they are not able to validate the debt, but you've made multiple payments before, Congress is telling you that you have the right to tell them where applicable they shall input such payments. So if it's going to go to your bank account, if you want them to mail it to you via a certified check or a cashier's check, Congress is saying you have the right to do all of that. No, this isn't Daraine telling you, not to pay your bills. Daraine is just breaking down what Congress is saying, and you need to operate how you see fit. All right. Oh, we did that. Legal actions by debt collector. So if y'all been in my rooms and hear me speak, y'all keep hearing me saying a debt collector is nobody. They have no legal right. Congress said it. They have no legal right. I am going to show you that a debt collector shouldn't even be suing anyone because they have no legal right. So please, please, please have your pens ready and your notepad and your drink. It's the pinky for me. All right, let's go. 15 USC 1692I, legal actions by debt collector. Now, Congress is so misleading, right? They're saying legal actions by a debt collector, right? When in fact, they already know that a debt collector has no legal right. But let's get into it. Venue. Any debt collector who brings any legal action on a debt against any consumer shall, in the case of an action to enforce an interest in real property securing the consumer's obligation, bring such action only in the judicial district or similar legal entity in which such real property is located. So if the property is in the Bronx, like, they can't be telling you that your court's in Queens. Like, the shit makes no sense. The property is located in the Bronx. Like, shit needs to be in the Bronx. In the case of an action not described in paragraph 1, bring such action only in the judicial district or similar legal entity. Now, A says in which such consumer signed the contract sued upon. So if the what is being referred to was not covered by one, well, if I signed the document in Staten Island, then you can't be suing me in the Bronx. Let's go to Staten Island. In which such consumer resides at the commencement of the action. So you're able to choose. And if these don't apply to you, it's a violation. So you need to understand that where is it? If they're bringing certain legal action, well, you reside at the commencement of the action. Well, bring it to my jurisdiction. Bring it here. Don't be telling me that you're in West Bubblefuck and I'm supposed to go there. No, I'm not. But disregard everything that I just said, because this right here, this B, small b with a thingy around it, this is the gold mine. Listen, any debt collector who brings any legal action on a debt against any consumer shall authorization of action. Nothing in this subchapter shall be construed to authorize the bringing of legal action by debt collectors. Yo, let's fucking go. Congress just told you a debt collector has no legal right to bring any action on any consumer. I'm going to read it again. Authorization of actions. Nothing in this subchapter shall be construed to authorize the bringing of legal action by debt collectors. Let's go. I told y'all they had no fucking legal right. Motherfuckers. All right.
Dang, let's go.
All right. Furnishing certain deceptive forms. All right. A lot of people are going to say, well, oh, I signed a contract and I did this. And well, let's see if Congress speaks on anything regarding to a contract. Furnishing certain deceptive forms. Congress does not speak about no contract. Contract isn't defined under here. Congress spoken about forms, right? So if someone's in court saying, well, you signed this contract. Well, signed this contract. I don't know what you're talking about. Congress told me what a form is, what a deceptive form is. I don't know nothing about no contract, man. Get away from me with that obscene and profane language. It is unlawful to design, compile, and furnish any form, knowing that such form would be used to create the false belief in a consumer that a person other than the creditor of such consumer is participating in the collection of or in an attempt to collect a debt such consumer allegedly owes such creditor when in fact such person is not so participating. Hold on for a minute. I went to the car dealership. They told me, well, I went there for a consumer credit transaction. They came back. They called me a borrower. I saw it on the paperwork. They told me I got a loan. I don't know what a loan is. And then someone else is attempting to collect the debt. Hold on, Daraine. What did you just say? Hold on. Yeah, I think I'm drinking too much. Hold on. I went to the car dealership. I used my social security card, which is a credit card. I went into a consumer credit transaction with my open-ended credit card. They came back. They told me I got a loan. I didn't go there for a loan. They told me I got a loan. They called me a borrower, okay? And then some bank sent me a bill or a statement that I owe something that's in a positive balance. Well, Daraine, what you said made no damn sense. What are you talking about? All right. Daraine uses social security card. You went to the car dealership. The car dealership took Daraine's social security card, which is Daraine's credit card. I went there for a consumer credit transaction. They took it. They came back. Here you go. We're giving you a loan. What is a loan? I didn't ask for a loan. I went for a vehicle. I gave you my instrument. You gave me a loan. You called me a borrower. I'm not a borrower. The Fdcpa says I'm a consumer and a natural person. I am not a borrower. Someone is furnishing certain deceptive forms. This is fraud. I'm gonna leave y'all to be the judge of that. I'm not gonna get into it. Think about it. I didn't went there for a loan. I went there for a consumer credit transaction. They took my social that has unlimited credit, came back, said they gave me a loan, but there was nothing deposited in my bank account. They billed me 30 days later telling me that I have a loan, or what? And I need to make this payment. I'm gonna just leave that one there. Civil liability. Now, for everyone that knows, this is my best friend. Civil liability. Please write this down. All night, you've heard me speak of for every violation under the Fdcpa, you are owed $1,000. This is where Congress tells you that. Amount of damages, except as otherwise provided by this section. Any debt collector who fails to comply with any provision of this subchapter with respect to any person is liable to such person in an amount equal to the sum of any actual damage sustained by such person as a result of the failure. If they failed to do anything that they're supposed to do under the Fdcpa, in the case of any action, anything at all, by an individual, such additional damages as the court may allow, but not exceeding $1,000 for every violation under the Fdcpa. You are owed $1,000. Let's fucking go. In the case of a class action, such amount for each named plaintiff as could be recovered under subparagraph A and 2, such amount as the court may allow for all other class members without regard to a minimum individual recovery that exceeding lesser of 500,000 or 1% of the net worth of the debt collector. All right. Factors considered by the court. All right. I'm gonna leave y'all to go through that part. I got the main point out. They owe you $1,000. Please read the rest of this. Please read the rest of this. Administrative enforcement. So basically now they're giving you resources where if you're violated, you're able to make complaints to the CFPB, the BBB, the Bureau. So let me go back a little bit. There's a difference between the CFPB, which is the Consumer Protection Financial Bureau, and the Bureau of Consumer Protection Finance. There's two of them. One's administrative the other one gets remedy done. So there's a difference between the two, okay? But this is just resources where they're telling you that you can file complaint with the FTC, the CFPB, Federal Trade Commission, different three-letter agencies that can assist you with your remedy. So those are the highlights for the Fdcpa. So what I'm going to do now is go back to the PowerPoint to make sure that I didn't miss anything. And I am going to make sure that I'm sharing my screen so y'all can see this. We're almost finished. We're literally right there. Okay, cool. So we're almost finished. So, all right. What you might be thinking. I know we've covered so much information, right? All right. What if a debt collector does not honor my cease and desist? You're going to document that you sent them this day. You remember you send certified mail, green return receipt, and you're going to have a copy of what you send. So if you tell them to stop calling you, but they're still calling you, then you're going to start writing your violations down. You're going to read and research the TCPA. Remember that, because anything that has to do with phone calls, the TCPA covers it, right? And you're going to start adding your violations up, because remember, every violation under the FDCPA is $1,000. What if a debt collector does not honor my specified remedy? Bring the ass to court, and this isn't legal advice. Bring the ass to court and be firm in your decision and what you want to do. What if a debt collector stops calling but still sends me mail? Well, it depends on the correspondence, because you can say, you know, cease and desist all telecommunication or all communications except communications by mail, because now we want to catch them in mail fraud. Oh, I'm glad I mentioned mail fraud. There's something that I want to show y'all. Where is this? New share. There's a few things I want to show y'all, to be honest, before I close out. You know, when you go to court and you kick the attorney out, remember, a corporation is a piece of paper. That's all it is, a piece of paper. Your Sixth Amendment right. Remember to invoke your Sixth Amendment right if you're ever in court. This isn't no way, shape, or form legal advice, but your Sixth Amendment right, right? The Sixth Amendment guarantees the rights of criminal defendants, including the right to call public trial without unnecessarily delay, the right to a lawyer, the right to an impartial jury, and the right to know who your accusers are. If XYZ collection is saying that you owe a debt, I need to speak to the person who's accusing me. I don't want to speak to a representative. Speak to me. You're accusing me of owing this alleged debt. You have me in court. Who is my accuser? My Sixth Amendment right gives me the right to know who my accusers are. So invoke your Sixth Amendment right. All right, that's one thing that I wanted to show y'all. There's another. New share. Okay. I hope y'all are writing these things down, you know. When you request for documents, do not take, I repeat, do not accept any copies. Rule 1002 or Rule 1002, requirement of the original. You will put this in your correspondence. An original writing recording, photograph is required in order to prove its content unless the rules of or a federal statute provides otherwise. The rule is the familiar one requiring production of the original document, the original of a document to prove its content, expanded to include writings, recordings, photographs as defined in Rule 10011. Please stop accepting copies. I want the original. You're going to invoke Rule 1002. You are requiring the original document. No copies are accepted. All right, so now that we got that out of the way. All right. Can y'all see what I'm doing? Yay, nay? Yes?
Yes.
Okay. Okay. If you're seeing volunteer non-fit injurer, let me know. Is that what you're seeing?
Yes.
Okay, so please write this down. That's why I'm going a little bit slow here, because I want y'all to write these points down. Volunteer non-fit injurer is Latin for to a willing person, it is not a wrong. The legal maxim holds that a person who knowingly and voluntarily risks danger cannot recover for any resulting injury. The principle was the common law basis for the assumption of risk. I'm going to go to assumption of risk in a minute. But basically what this is saying, a debt collector knowingly bought bad debt of people not paying, and now they're trying to drag y'all to court, which we know that they can't because they have no legal right. Drag y'all to court to go seek remedy. No, volunteering non-fit injurer says you willingly know these are bad debts. You are at fault. I am not at fault for you buying bad debts and now you want to collect. You are not at fault. So make sure that you have this in your arsenal. All right? Look it up, understand the words that are being used. Let's go to assumption of risk. Potential plaintiffs sometimes take the risk of injury onto themselves because that's what they did. They took the risk of injury buying bad debts and absolve potential defendants from any liability. Formerly, this was an affirmative defense available to defendants. So you as the defendant, you must say they took the risk of buying these bad debts. Now you're dragging me to court because you made a bad business move. No, bro, no. You're gonna say that, state that in court, understand what it means, and stand firm behind what you're saying. Now let's go to affirmative defense. This is a defense in which the defendant introduces evidence. So this is where you're gonna say, you know, if you were in hard times, you lost your job, a death in the family, a divorce, something. These are where you're gonna put your evidence there, and you're gonna make it known that because he made the bad decision, you're dragging me through the mud for a bad decision that you made. Nah, bro, that's not how it works. So get familiar with these different maxims and how you can use them towards your benefit. All right, there is something else I had for y'all. What else was it? Okay, boom. So now we're at frauds and swindlers. So 18 USC 1341. This is very long. I'm not gonna go through it. But what I want y'all to know is when we speak about mail fraud, because they know it's bad debt, they know they can collect on the debt, but they try to anyway. This is the section that backs you up for mail fraud, especially when they furnish certain deceptive forms and then they're trying to collect. So understand what frauds and swindles mean. And this is the code 18 USC 1341 that speaks on mail fraud, okay? That's why we want all communications through the mail, because you're going to get them on mail fraud. All right, we spoke about the TCPA. Spoke about the affidavit already. All right. Let's touch on what aggravated identity theft is. This is absolutely critical that you know what this is. Please write down in your notes, 18 USC 1028A. So for those who have child support, this is where that identity theft comes in. If someone uses any identification of you, this is where this is coming. So whether you went to a dealership, they shotgun your credit, stuff like that, this is where this language is going to come in. And this is why when you in the bundle, or right now the Credit Hero package, there are certain letters in there that speaks on aggravated identity theft, right? So let's get into it. In general, whoever during and in relation to any felony violation enumerated in subsection C knowingly transfers, possesses, or uses without lawful authority a means of identification of another shall, in addition to the punishment provided for such felony, be sentenced to the term of imprisonment of 2 years. So if someone stole your identity, and stealing your identity doesn't simply mean they went to go open mad credit cards. It's as simple as your reputation, because they need certain information to access your consumer report. So someone used an identification of you that you didn't give permission to. So in addition to permissible purpose, which is when we read the ebook, for those who brought the my ebook with them, Do for Self, the Educated Consumer's Guide to Repairing Your Own Credit, you're going to see the permissible purpose section, and the letter speaks about how to get inquiries removed if you have no business with the creditor who initiated the inquiry on your consumer report. Someone used an identification of you that you didn't give permission to use. So this is where you built this in. It should already be built in the letter. And this is where you're going to use it to remove inquiries. You can use it to remove a lot of things. It's really about studying and the application of your articulation to get your desired remedy. All right, so we covered that. We spoke about this already. Spoke about that. Now we are here. So now we are in the final part of this whole presentation. This letter that you see in front of you is the most powerful letter that I have in my arsenal. So if y'all can see the screen, please let me know. You should be seeing a letter that says demand for validation and proof of claim.
Yes.
Is that what y'all are seeing?
Yes.
All right, so let's go. My drink is almost finished. Let's hope it carries me through.
But we cannot see the entire letter.
That's fine, because I'm gonna go through it. Don't worry about it.
You're the man.
All right. So I'm gonna ask everybody to go back on mute, and I'm gonna go through this letter because we finna get turned up. All right.
All right.
All right. So, to whom it may concern, this letter is being sent to you. And my eyes are bad. Let me zoom this damn thing up because I don't know why the damn letters are so fine. Next thing you know, I need glasses. Shit. All right, there we go. Whew, damn. Okay, boom. This letter is being sent to you in response to a computer-generated undersigned letter dated. So the dates in here are fictitious. So just go with the narrative for me, all right? Letter received by claimant, which is me, the claimant, from your offices, which is the debt collection office that I'm requesting it from. So, you know, when you tell them you need this thing validated, they're going to send you like statements and bills and all sorts of generated stuff. So this is what this letter is addressing. But remember, it's not just using a letter that you get. You should be able to tailor the letter to fit your situation. So these fictitious dates that you see, those need to be replaced with real dates. You need to make this personalized for you. Like I can give you a guide, but you have to put the pieces together. All right. So be advised that your claim is disputed and validation and proof of claim of the disputed debt is requested in accordance with the Fair Debt Collection Practices Act, 15 USC 1692G, and as amended by adding the following new titles, new Title 8 USC 802, the Fair Credit Billing Act, 15 USC 1666, and all of which were conjunction in which other, including the Truth in Lending Act, 15 USC 1601. It is not, nor has it ever been my intention to avoid paying any obligation. So please note the language that is being used. It's absolutely critical before you send this out, you understand the language. Everyone that's on the Zoom tonight, you will get a copy of this letter. Paying any obligation that is lawfully owed by the claimant in order to make arrangements to pay any obligation which may be lawfully owed. Please document and verify the debt by complying in good faith with the request for validation and return it to me within 30 days of the receipt of this letter. This is not a request for a verification or proof of claimant mailing address, but a request for validation and proof of claim made pursuant the above named titles and section. I respectfully request that your offices provide claimant with the competent evidence as per the attached declaration and proof of claim that I have any legal obligation to pay you the unsubstantiated alleged debt. You notice it keeps referring to alleged. It's not taking ownership. Everything is alleged until it's proven. Furthermore, you shall cease. So this is the cease and desist part. So first we saw the validation, right? Now they're hitting, this letter is hitting the cease and desist portion of it. According to 15 USC 1692 CC. You shall cease. So the first part was 15 USC 1692G, validation of debt. Now we're hitting 15 USC 1692 CC, which is the communication part, which speaks on cease and desist. You shall cease all verbal communication. So make very clear, no phone calls to the claimant. Don't call me. So now that you've said that, if they call you after receiving this, this is why you're going to send this correspondent certified mail, green return receipt, so you know when they got it and you're able to prove that you sent it. You told them not to contact you by phone, but they still do. So you're going to get that $1,000 under the Fdcpa, and then you're going to go to the TCPA and you're going to get $1,500 for every time they called you. At this time, I will also inform you that if your offices have reported invalidated information to any of the three major credit bureaus, such as Experian, Equifax, TransUnion, prior to the validation and proof of claim of the disputed debt, this action might constitute fraud for both federal and state laws. Due to this fact, if any negative mark is found on any claimant, which is you, credit report by your company or the company that you represent, I will not hesitate to bring legal action against you and your client for the following. Now, when we talk about running up a bag, we're going to run up a bag right now. Violation of the FCRA, violation of the Fdcpa, defamation of character, violation of the United States Code, Title 18, Part 1, Chapter 63, 1341. Remember, we spoke about mail fraud earlier? So this is now mail fraud because you ask for something pursuant to the law. They're avoiding it. They're not giving it to you. They're sending out false accusations and basically committing fraud. And this is where you're going to get them, right? This debt is considered to be invalid until I receive proper verification and your offices provide claimant with proof of claim of the disputed debt. Your offices have 30 days to produce the required documentation because under 15 USC 1692G, it does says you have 30 days. Accordance with the FTC guidelines, during this validation period and proof of claim, if any action is taken which could be considered detrimental to any of the claimant's consumer report, and said action will be considered dishonor because now you, out of good faith, tell them what you're requesting as per the law, but now they're acting dishonorably by not complying with the law. So they're dishonored now. They're not operating in honor anymore. And it's important that these specific words are used and cause the self-executing contract. So remember when I told you about there's a built-in self-executing contract? It's built inside of this. So we're putting them on notice that if you dishonor the request, your dishonor will cause the self-executing contract to be implemented. This includes any listing of any information to a credit reporting repository or agency that could be inaccurate or invalidated. If your offices fail to respond to this validation and proof of claim request within 30 days from the date of your receipt, how are you going to prove that they received it? Certified mail, green return receipt, because when it comes back to you, it's going to tell you the day when they got it. So you calculate 30 days from then, and if they haven't responded in that time, this self-executing contract is in full effect. Must be deleted, completed, remove, claimant, credit file. All right, cool. Title 8 USC 809, validation of debt. We just covered that. So I'm not going to read that part. Black's Dictionary, they're just breaking, the letters breaking down certain words. Verification, confirmation of correctness, truth, and authenticity by affidavit. There's a built-in affidavit in this as well. Oath or disposition. Counterclaim with self-executing contract. So this self-executing contract, this part, if they don't operate in honor, right? And if they disregard the requests being made, that dishonor puts this self-executing contract in full effect. So let's read what the self-executing contract states. If respondent, such by commission, omission, and otherwise fails to provide validation and proof of claim within 30 days, the contract is executed. Makes false representation of the character of the herein above referenced alleged debt, it's activated. Makes false representation of the legal status of the herein above referenced alleged debt, it's activated. Makes any threat of action that cannot be legally taken in violation of any applicable law, such as the law codified in the Fair Debt Collection Practices Act, it's activated. Will be construed to the respondent tacit acceptance of the terms and conditions stated herein, in which in which case respondent agrees to. So let me read that over. I do apologize. Okay. Will be construed to the respondent tactic. Yep. Acceptance of the terms and conditions stated herein, in which case respondent agrees to. So this is what they're agreeing to. So this contract, it's like a, I'm not gonna say bulletproof, but it is so tight that the line is so thin, just produce what I'm asking for. Because if this is what they're agreeing to now, voluntarily report this account to all credit bureaus as paid. This is what they're agreeing to. So if this self-executing contract ever takes effect, this is what they're agreeing to now. Voluntarily waive all claims against their agents or heirs with prejudice. The matter regarding the alleged debt is finally and totally settled. Voluntarily admits the claimant is the depositor for this account, that the respondent risks no one of their assets at any time regarding the account. All right. Voluntarily report the date of last activity on this account as the date of this notice. Furthermore, respondent's failure to cease and desist in accordance with the requirements under the Fdcpa. So if the cease and desist was sent out, which it is, and they fail to abide by what the cease and desist states as per the Fdcpa, they're in violation and it activates this self-executing contract. The above terms and condition constitute respondent's breach of duty and voluntarily agreement to compensate claimant by certified mail. So I'm gonna read this part over because this part right here is where your remedy comes in. Furthermore, respondent failure to cease and desist in accordance with the requirement of the Fdcpa and other related law and or satisfy the above terms and condition constitute respondent's breach of duty and voluntarily agreement to compensate claimant. So they're agreeing to compensate me if they deem to be dishonor and they break any portions of the law by certified mail. So they're gonna either send me a check by certified mail or a cashier's check within 30 days of the date of the billing by claiming their agent or heirs in the following amounts. Let's go. $1,000 for each communication made to claimant or the agent, which is if you have like a lawyer or something like that, or if your family, let's say something happens to you and your family, your kids, wife, whatnot, somebody is executing on your behalf, whether telephoning or in writing, which is not in affidavit form by a person who has firsthand knowledge regarding respondents' unsubstantiated claim. I'm gonna read that over. $1,000 for each communication made to claimant or their agent or heirs, whether by telephone or in writing, which is not in an affidavit form. This is saying that they must respond with an affidavit by a person who has firsthand knowledge regarding respondent's claim. So whoever is responding, they must have firsthand knowledge. And what this is saying is, if the person that is responding does not have firsthand knowledge and doesn't reply with an affidavit, $1,000. $50,000 for each transaction initiated by claimant where claimant's commercial ability is impeded due to you. So if I have issue because you're furnishing deceptive information on my consumer report, I am coming after you because for damages, because I can't operate, I can't do nothing, my character is damaged, my household is at a disadvantage because of you, I'm getting you for 50,000. 5,000 for each court appearance. Claimant. So if I go to court every single time I'm going, this is all the things they're agreeing to if they fail to do what I'm asking. $5,000 for each trip to the court. Respondent owes claimant the balance equal to the prorated credit limit on the account plus interest and fees and money lent. So everything that they're attempting to collect, I want that. So remember when it spoke about invoking specified remedy? Remember, I told you the collection company can invoke it, but you have the same right to invoke specified remedy to you. Well, what is your specified remedy? Like, how much did their furnishing of the deceptive information cost you? I can't answer that for you. That's why you got to study and you have to go through and make notes of the stuff. All right. 3 times the alleged claim. So whatever the claim is, so just using numbers here. So let's say the claim was for 165,000. Well, I want 3 times that amount. All right. $5,000 per occurrence for listing or reporting any information to a credit reporting repository, which could be considered detrimental to the claimant. So if they are still furnishing the information on the consumer report, you can charge them $5,000. There's a couple ways that you could go with this. The numbers here are numbers that you can adjust. These numbers are not just set in stone. It's like I said, these numbers and dates and stuff, they're fictitious. You got to make your own what's specified to you. But for this one, number 6, the $5,000 per occurrence for listing on a consumer reporting any information to a credit reporting repository, which could be considered detrimental to the claimant's credit history. Well, you can do 5,000 per day because there is no real quantification as to the direction that it can go. So now we're talking about if you've been furnishing this information for 5 years, well, guess what? 5 years at $5,000 per day. If that's your remedy, I can't tell you what your remedy is. Punitive damages in the amount of 272,000, whatever your punitive damages, I don't know. Debt collector tactically agrees that debt collector will compensate responders for all costs, fees, expenses incurred in defending against this and any and all continued collection attempts. All right. Respondent also agrees, number 1, voluntarily authorize claimant to all right. Remember I told y'all that you can put a lien on a debt collector. Respondent also agrees. So if they violate this in any way, shape, or form, they are actually authorizing you to record a UCC1 on the respondent as debtor to secure the debt owed claimant. So if you state all your claims, you now have them in a corner where now they also agree because they violated this and then it triggered the self-executing contract. So they agree to they voluntarily authorize you, the claimant, to record a UCC1. All right, let's find out what a UCC1 is. Bear with me for 1 second while I pull this up. New share, Google, UCC1. Definition. All right, not that one. Where is it? I had a very good definition the other day. All right, so we're in a government website. It should give us from now. All right, I'm not seeing the explanation that I had the other day, but I want y'all to write, and Vistapedia might have it. Let's see. Okay, well, here we go. All right. Please let me know if y'all are seeing the screen. Are y'all seeing the definition for a UCC one? Yay, nay. Yes, no, yes.
Yes.
Okay, good. What is a UCC1 statement? A UCC, Uniform Commercial Code 1, a statement is a legal notice filed by a creditor as a way to publicly declare their rights to potentially obtain the personal properties of debtors who default on business loans they extend, often abbreviated as UCC1. These notices are typically printed in local newspaper, yada, yada, yada. So basically, key takeaways, let's see. A UCC1 statement is a legal notice filed by a creditor because remember, you are a creditor, all right? In an effort to publicly declare their rights to seize assets of the debt collector. So in the self-executing contract, they agree for you to put a UCC1, basically a lien on them. So in the event that they can't pay, you can seize the assets of the debt collectors. UCC1 notices are typically printed in local. We got that. The forms are mainly used for smooth out collection processes, often by helping lenders secure court orders authorizing them to seize assets from delinquent borrowers. So if when you put this lien and you invoke all your remedies and you want to get paid and they're unable to pay, but the self-executing contract was in effect and you decided, listen, I'm going to sue them, I'm going to seize all their assets, I'm going to liquidate. This is what's going to give you the power to do that. All right, so now that we got that out the way, where were we? All right, I'm back to the debt validation. Are you able to see the debt validation letter still? Or is it still on the other one?
Yes.
Okay, perfect. All right, voluntarily prove their claim as a respondent in possession of claimant property in an individual bankruptcy. So basically, if they go for bankruptcy, you're still gonna claim everything because you have first lien. All right, resolve all claims by claimant against respondent exclusively and finally through binding arbitration, if necessary to enforce the above terms, fees, penalties, damages. Arbitration replaces the right to go to court. So basically, you're going to pick an arbitrator, you're going to provide the evidence, the arbitrator is going to say, yay, nay, you win, yada, yada, yada. The arbitration organization that is selected will apply its code and the procedure in effect for the time of arbitration is filed. Subject to this agreement, the arbitration will be conducted before a single arbitrator. The arbitrator's authority is limited solely to the claims between the two. So what this is saying is it's based on evidence and claims. So what is being produced? They can't bring in nothing outside of the claims that are being discussed at the moment. That's what the decision will be made primarily from. Final binding parties, judgment entered in the court, competent jurisdiction, the abbreviation. All right. This is a private communication and the intent to effect out of court settlement. So now you're also giving them the option to do an out of court settlement. Conduct yourselves accordingly. Should any provision of this agreement be found to not be enforceable by order of a court, competent jurisdiction, it shall not adversely affect any other provision in this agreement, and responsible opportunity and effect shall be taken to modify it to become enforceable. So basically, if wherever you're invoking your specified remedy from, if the term, that's why you need now to make sure that a lawyer reviews this document and tailor it to the laws specific to where you are, because Not everything in here will apply to you wherever you are. So it's important that you get this evaluated and then tailored to your specific region. Equity under the law is paramount and mandatory by law. Notice to the principal. Okay, this statement right here, notice to the principal is notice to the agent. Notice to the agent is notice to principal. That's a statement that you need to understand. It doesn't matter who gets it. Once someone gets it in the company, it goes all the way to the principal. Don't care, not my problem, whatever structure y'all have in place. And basically, you're just going to go further down. It's going to tell you a list of stuff that you need. I'm not going to go through all of it because it's a few pages, but I think I got the main points noted. And this is where now you're going to do your affidavit. So down here is really an affidavit. And remember, an affidavit needs to be rebutted line by line. And then now you want to get a notary to make sure that they sign your affidavit. And you can even go a step further and do a notary presentment. So, like I said, it's the most powerful letter that I have in my arsenal. It is the most powerful letter that I have in my arsenal. And because y'all came to the Zoom, y'all will be getting this letter. All right, stop share. I know this has been a lot of information. I told y'all this wasn't, it's not something you just get one time. It's like hooking up a garden hose to a fire hydrant. It's a lot of information. And I think I left off down here. I'm going to just answer some of these because answering some of these might answer a lot of some of the questions y'all have. And then we'll go into open mic, open Q&A. Can I send an affidavit with my cease and desist? As you just saw, yes, you can. What is an affidavit? We covered that earlier with the definition. So if you type into Google what an affidavit is, it's going to tell you that it's a sworn statement made under oath. Can I request validation with a cease and desist? Yes, we just saw that. Does signing a contract grants a debt collector the right permission to contact me? It depends on what's in the contract. That's where the evaluation of the contract will need, because we need to know what type of language is in there. What if they didn't respond to my request for validation? Well, that's a violation under the Fdcpa and you're owed $1,000. What if they respond with bills and a statement? Well, we know that if they respond with bills and statement, it still doesn't validate a debt. Enforce your right, demand what you need. What if they do not provide me with all 5 requirements required under the Fdcpa? Then for each one that they didn't provide for you is a violation of that section and you're owed $1,000 per violation. What if they respond to my request for validation with a contract with my signature? Well, okay, let's play that game. First of all, a contract is not defined under the Fdcpa. That's number one. A contract with a signature does not validate a debt. Under the Fdcpa, 15 U.S.C. 1692G, Rule 1002 require the original contract. We're not dealing with no copies. We want the original contract. Can a debt collector sue me? Can they? They can if you let them. We know, according to 15 U.S.C. 1692, a debt collector has no legal right to bring any action against anyone. What do I do if I am sued? Show up to court, make sure you study, read the Fdcpa, understand the Fdcpa. Make sure you kick out any attorney that might be present. Can a debt collector get a default judgment against me? They can if you let them. A default judgment is illegal, and we spoke about that earlier. What if they say they are not a debt collector? Well, if you're not a debt collector, then why are you contacting me regarding the collection of a debt? Like, bruh. Okay, so we did that. All right. Want to let y'all know that the ebook is on the website. I just got to show y'all this real quick. All right. Now that we got that out of the way, yes, but the ebook is available. It's on the website. It has tons of stuff. The letters are there. Everyone that came to the Zoom tonight will get a copy of the FDCPA. And now we are open for Q&A. I see a lot of hands raised. Nish, are you still with me? Let's go through and answer the questions from everyone that has their hand raised. Nish, are you still here?
I'm here, but I have a little noisy background, so I think we should go in the order.
Okay, let's see. Abir, are you here? Abir. Okay, probably not. Okay, so the first, yeah, I'm just gonna go in order. Let me just check what's going on. Okay, cool. All right, Audrey, I see your hand raised. Where is Audrey?
I'm right here.
Hey, what's going on? First of all, let me say thank y'all so much for sticking with me. 8 and 3, that's what, 11. We're here 3 hours, and y'all are still here. So I want to say thank you all. Let's get into what you got. What's your question?
Okay, real quick scenario, and you can let me know. It's just the weirdest situation. I had a lawsuit 6 years ago that I initiated for a bad medical lawsuit. Almost lost my foot. That's it. I had an attorney, and the attorney, when I went into the contract, he had said to me, "You're going to have a lot of fees." And I said, "Well, I can't afford all these fees." I wrote a document with him and said, "I can only afford 35,000 of it. The rest is on you." Anyways, he had a medical doctor that was the medical doctor proving my case. His agreement with the medical doctor, I went in and signed some papers. He said, "Go see that doctor and get a X-ray." I did so. Here we are, 6 years later. About 6 months ago, I received a call from a collection agency. Had no idea, out of the blue. And 2 months after that, an $80,000 collection on my credit.
Really?
So, yeah. And so here I am right now. I've never spoken to him. I've never received a bill. I have never even known that I owed, so allegedly, that doctor money. I had never, and it's been 6 years. The attorney never paid them. So
quick
so here,
question. What state are you in?
California.
What's the statute of limitation? So you need write this down, please. What is the statute of limitation to collect medical debt in California? So you need to write that down and then find the answer. Then number 2, the correspondence. Just like what we went through tonight, you're going to evaluate every single correspondence.
I've only received one
So that's fine.
this week. That's it. 6
there a-
years later. One.
The statute of limitation is very important because let's say if you're past the statute of limitation for collecting on that debt, then you need to respond stating that this alleged debt is past the statute of limitation. So it's important that you know what the statute of limitation is for collecting on medical debt in California. And if it's past it, you respond accordingly. And then everything that we went through tonight, evaluate the correspondence, discern the language, break it apart. Every violation is $1,000.
So at this point, am I asking them to pay me? Because in your other one, you said in the letter, it says, if you don't, you'll owe me all this money.
Well, remember we talked about the self-executing contract?
Yes.
So this is where, no, you're going to tailor it. So the letter that I just read, you're going to get it. right? And remember, Daraine doesn't give legal advice. This isn't legal advice. And you want to get the letter evaluated before you use it because obviously you want to understand what the language of the letter is saying. So once you're able to discern the language and you tailor it now for your specific situation for California, send them the letter.
Okay. And then what you said, when they say their name and a professional collection corporation, and when they say things at the bottom, an attempt to collect debt, that is a violation. They just incriminated, and then they even put terms of a loan that I don't even know about. Another, what is the loan? I mean, like, I don't even know what $81,000. Never heard of this.
Is it in a negative balance or a positive balance?
Do
you see a minus sign before it?
No.
So, deceptive forms. So if I owe something, how is it in a positive balance if I owe it?
I don't even know what the terms of interest are. What terms did I sign?
There we go. So now you're going to get your book, your paper, and your drink, whether it's water or a nice cocktail, pinky up.
A lot of money.
Yes, and you're gonna go through the Fdcpa. So you're gonna get a copy of the letter, and you're gonna go through. You're gonna overstand, not understand. You're gonna overstand the language being used, and you're gonna go after them, and you're gonna make sure that the self-executing contract is in there. So if they operate if they operate in dishonor, it triggers the self-executing contract. That's why you got to understand what's in there, because if you don't understand it, then they'll be able to push you over. But once you get the language, enforce your remedy.
The only last thing I have to say is that my attorney, who said, I'm willing to do everything, whatever, he said, the only thing that they might have you on, so he thinks, because he doesn't know the laws like you do, but he said that you signed, when you go to the doctors and you sign at the bottom that you're responsible for the debt.
Bullshit.
And that's what he said.
That's not a validation of that. We just went through it. A signature on a piece of paper or a contract does not validate.
If I sued them, that would never hold up in a court of law for them.
It's all about language. And remember, if they get an attorney, well, we all know no correspondence should be coming from an attorney. And they have no legal right to sue anyway. We just went through it. So now it's about your articulation and how you're going to study and how you're going to present yourself. But I do suggest that you work with a consumer protection lawyer that you can get more guidance from, because Daraine does not give legal advice. So, but you knowing this information gives you a better view of how you're going to operate. And that's extremely, extremely important.
Thank you, sir.
You're welcome. All right, who do we have next? Brandon Bailey. Unmute yourself, Brandon. What's your beef?
What's up, bro?
Yo, what's poppin'?
Bro, I'm sorry, but I've been in and out of this because I'm on a date. So this is kind of challenging to me. So I'm a little bit like, I'm going excited, crazy, all over the place. But I was wondering, can I share my screen? Because I wanted you to look at the collections on this credit report and kind of see what we can attack.
So just read it to me. Just let me know what's going on, because we can, I'm not too savvy on the Zoom shit, and I don't want to do something that's going to mess this up, and then I throw everybody off.
I feel you.
So dude, you have your laptop doing work on a date and listening to the Zoom?
I know, he's like
bruh.
Brandon, go ahead and try now.
Okay, all right, here, let me try. Okay. Wow. So can you see the screen?
Oh yeah, okay,
yes.
Cool. Yeah.
So let me move this over. How do I move?
On a date, listening to the Zoom and doing work. Yo, bruh.
That's what you call multitasking right there. He means business.
Bruh.
He's not missing this Zoom call. No way.
That's what you call running up the bag.
Right.
Yeah, so she has this Midland collection, but we've been disputing this shit, but I know that I didn't dispute it because I'm not a dispute person, but but the company that, you know, we hired to do it, but obviously it's still on here. So there's something that's missing of how to attack this the right way.
You didn't hit them with a validation of that. That's why the letter that you're gonna get tonight, just tailor it to your clients and send it to them.
Okay, so let me ask you this. So, but I send it directly to the creditor, right?
Yeah, you're not sending this to the credit bureau. You're sending it directly to the. Remember, a collection agency is not a creditor. You're
Right.
sending it to Midland. If Midland is the one that put it on there, they are the ones you're going after.
But that's only for Midland, not for Bank of America, though, right?
So where do you see Bank of America?
Right here. Do you see it?
That's the same account.
No, it's a different account.
So if Bank of America is acting as a, let's see what it's categorized. Charge off collection. All right, so there's two things here, the inaccuracy and the confusion, because it's saying collection and it's saying charge off. Well, which one is it? Like, bro, which one is it? Is it a collection or is it charge off? So now when we speak about charge off, okay, you're gonna have your client request your 1099-C, which is a cancellation of debt, right?
Right.
Because if it's listed as a charge off, which you can see in the consumer report, it means they got a tax break for it. So now getting a tax break for it, I need my 1099-C because I'm supposed to report that to the IRS as gross income. Now, if it's income, income is not debt. Therefore, the status of this account has changed because you charged it off. It became gross income. This is not a debt anymore, and income does not get reported on a consumer report.
Right, got it. Okay, so but now let me ask you this. Now this is Pat. So California statute of limitations is 4 years from the date that it goes negative, right?
Uh-huh.
So, but obviously FCRA, according to that, is 7 years that it remains on the report. So next year it's going to be gone. So do you think that all these that are going to be gone, do you think it's worth effing with it than to like?
That becomes a personal choice, because if you want to make some moves right now, take that shit off. And then remember, this isn't the FCRA, so I'll save that for the next class, but I'll touch it anyway. Approvals that come from that arise from the using of your credit card, which is your social security card, is not included. The term consumer report does not include that definition. So again, you can get it off. I'll go more into how you remove other accounts in the FCRA Zoom that I'm going to do. You can remove any account under the FCRA, any account you can remove.
Okay, that makes sense. Yeah, I just want to know because this is my friend, so I just want to help her out.
Yeah, no problem.
So
Daraine, can you repeat the 1099 part one more time?
So when there's a charge off, it means that someone wrote it off as bad debt and they got a tax break for it, right? So you, the consumer, request your 1099-C cancellation of debt from the company because you need to file that as gross income. It needs to be filed as income because if you're not paying it, it becomes income. But it becoming income and not a debt anymore, that changes the status of what's being reported because now you're going to show that you filed your 1099-C and this debt that's reported, that's an inaccurate account because you don't owe any debt. It's now income because you filed it with your taxes. This is income, and income is not supposed to be reported on your consumer report. But not only that, if they can't provide you your 1099-C, this is where we're going to talk about tax fraud because you're furnishing it now as a charge off. And you're telling me that my understanding of charge off is I'm supposed to get a 1099-C and report it to the IRS. So are you fraudulently putting stuff on the report? Did you fraudulently file tax? I'm not even going to ask you all of that because what I'm going to do now is I am going to report you to the IRS. So if you Google, what is it that I had? How to file how to file tax fraud, it's gonna bring you to a page on the IRS, and you go file your claim. You go make your claim. You make it to the CFPB. You're gonna make it to everybody. The CFPB, the FTC, the IRS, the BBB. It's tax fraud. Because if you can't produce me my 1099-C, but yet you're telling me that you have this account as a charge off, there's some fraud and some deception going on here. Nish, are you able to take back share from Brandon? Not sure. Brandon, can you end share screen?
Okay, yeah.
Okay, good. So that's the
Also for
thing.
Brandon, just to check the chat, because a lot of persons, they were like giving insights as well since you were sharing your screen. But thank you for sharing. We'll move on to Delia.
Absolutely, thank you.
Where's Delia? What's up, D?
Hey, how you doing?
I'm good. What's up?
Ah,
I got a little bit of drink left.
all right, all right. So I got a couple of things. I just want to get some clarity for an account I have on my TransUnion credit report
Mhm.
for Fed loan servicing. It's closed, but it's of course reporting as a derogatory account. So do I send them a validation of debt along with the cease and desist?
No, if it's closed, it's closed.
Yeah, that's
You
what
have
I
the
was-
you have the bundle, right?
Yep.
Okay. In the bundle, there should be a letter that says student loan deletion letter. You remember seeing it?
Student loan deletion letter.
Yeah, there's a student loan deletion letter in the
All
bundle.
right, I'll find it. I printed out some of the letters,
Mhm.
so.
You're gonna send that directly to Fed loan.
Okay,
If not, if you don't find it, just hit me up on the back channels and we'll discuss it. But you should have received a letter that says student loan deletion letter.
and I said I'd send that letter directly to them.
Going to Fed loan, correct? Yes.
Okay, got it. All right, so the other thing is, I think I had told you this, well, we could discuss this offline. It's about the copy of the contract I received from Santander in regards to the repo.
Don't worry, I'm gonna set you up with I
Okay.
got you. I'm gonna set
All
you
right.
up with that.
And then the other thing is, so US Department of Education, has me reporting in the positive, or it has has been reporting me positive since the whole fiasco with reporting me as a charge off closed. The account was charged off and closed. And then miraculously, it's not reporting positive. So with that, do I need to do the debt validation along with the cease and desist?
So a debt validation is in response to a collections account. So not everything you'll hit with a debt validation letter. It depends on what you want. So is it that you want to keep the account or you want to get rid of it?
I want to keep it because it is reporting positive.
Okay. Is it an opener? You said it's open or closed?
It's open.
It's open. So what's the problem that you're having with it? What's the issue with the account?
There is no issue other than I have a student loan. So I guess I don't want it.
So the account's in good standing, everything is good with it?
Yeah.
Alright, if it's good, then you don't need to fuck with it. If it was, let's say there was late payments and some other shit on there, then I'd give you a different remedy to get that off. But if the account is in good standings and it's reporting positively, what maximize on whatever it's gonna give you. Don't fuck with it.
Yeah, but I think ultimately what I would like to do is to get rid of the loan altogether.
So
I
if
don't
you
see
do,
anything.
just know that there will be a drop in your credit score because you're going to be removing that history. So you might get a significant drop. Just keep that in mind.
Okay.
If you are going to remove it, the student loan letter is there to remove it. But just know you will experience a drop because you're removing that history. Everything is
Now-
going to change.
Now, Okay, so I guess how I'm thinking, how I think about it is, wouldn't I be able to use, I can't remember what law off the top of my head.
It depends what's your intention for it, because if your intentions aren't clear, then you might do something that you might regret. You got to
Right.
have what's your intention for the account?
So my
what's your-
intention is to not have to pay on the account, but still have it reporting, be closed as a positive
Well,
account.
Well, you paying on it, there's not much I can do about that. What I can do is tell you how to get it off the report if you need it to get off the report. If it's in, there's late payments, I can tell you how to get rid of those late payments. That's the type of stuff that I can do. But as it pertains to you not paying a debt, that's a choice you have to make.
Okay,
Mhm.
got it. All right. And then the last thing I wanted to ask you was, I had this debt from like 2004. The original, right? And they just put it back on my credit report. It was just for Discover, and this company called Synergetic Communications has it. So I definitely know I'm gonna write a
Validation of that. Yep.
along with the cease and desist.
Yep. That's what you direct that for. Yep.
Okay. All right. And then in order to like seek remedy, because they're reporting something, defamation of character.
Mhm.
Do I then send them an affidavit of truth?
Well, so there's a misconception with an affidavit of truth. A lot of people call it, it's not really an affidavit of truth. An affidavit is a statement of facts.
Of facts.
They're
Okay.
your facts. You get what I'm saying? So if it's your truth, it's your truth. But a lot of people say affidavit of truth. It doesn't really matter.
Yeah, so it's really affidavit of
Remember,
facts.
so remember, the letter that you're gonna get tonight, it has a built-in affidavit inside of there already.
Okay.
So there's the cease and desist, the validation of debt, the self-executing contract, and the affidavit that's built into one letter, plus the UCC one, or you put a lien on them. That's why when you get this letter, spend some time to learn the letter, because if you don't understand the contents of it, you can put yourself in some hot water. Learn the language and then go out and go get what you need.
Got it. All right. Thank you so much.
You're welcome. All right, next we have Kirin, Kirin. Can't hear you, Queen.
How about now?
Yep. Perfect.
Hi. How's everyone doing tonight?
Good.
I first saw you, I think, earlier on this week with Uncle Don and Flame. And so when I saw you had this coming up this weekend, I wanted to jump on it because you said something, and it was because I was talking about a closed account that was had late payments on it. You said, well, actually, late payments are illegal. And so I was like, well, I'll just ask him that later and then leave the room for other people. So what did you mean by that?
So, well, all right, since we're going down the rabbit hole, this is a FDCPA Zoom. The late payment is on the FCRA, but I'll touch into it a little bit, even though I should reserve that for that. But in a nutshell, a late payment is illegal because Congress says that your transaction or experiences between a person or between a consumer, which is a natural person, and the person making the report. So we have the consumer, natural person, and the person making the report, which is an individual, organization, corporation, governmental agency, subdivision, yada, 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 should not be included on your consumer report. So write this down, 15 USC. I'll wait until, you got a pen?
I got it.
Okay, so it's 15 USC 1681 A. Then you're gonna put number 2.
Okay.
Then you're gonna put A and then I.
Okay.
When you go to that section, it's going to speak to you on why late payments are illegal and should not be included on your consumer report.
Okay. Thank you.
No problem. Next, we have Raven Cheek. Raven going once.
Hey,
Raven. I don't know why I'm saying Raven. Raven.
yeah.
Jesus. This Appleton got me a little twisted.
How are you today?
I'm good. How are you doing?
I'm good. Okay, so
Delia, pinky up. Hold on. Delia, pinky up. I caught you. Yep. Pink. Yep. There we go. All right. I'm sorry. Go ahead.
okay. So I wanted to just kind of reiterate when you have medical debt,
Mhm.
that is a what do you say? We can't validate, but we do what with the medical debt? What?
You treat a medic. Is it in collection status?
Yes.
Yeah, you treat it just like you would any other collection.
Okay.
You hit them with a validation of debt. But I do have a medical debt collection letter. So what I'll do is everyone that's on the Zoom, I'll send you both the validation of debt and with a self-executing contract. And so you're gonna get two letters. You're gonna get one for medical collection as well. So when you get it, spend some time to study those letters, and then if you want to go see a lawyer just to check that everything's up to date, get that done, and then tailor it to you, and then you send it out. But you're gonna get two letters. You're gonna get two letters.
So I was listening to this person and they were saying that an affidavit, you could actually write a check and tell them the amount you're going to pay, write it on the back of the check and say, this is all I'm going to pay. And, and that's it. And if they cash it or something like that, is that true? I don't know.
I don't know about all the sorcery in the world. I just know some sorcery. I've never heard of that one. It could be a new spell they haven't taught me yet at Hogwarts. So
I heard Christine say it, but she was like, you can put on the back of the check, and if they cash that, somebody said Raven speaking of accord instead of satisfaction.
So there's things called instruments. So I'm not gonna say that that's wrong. You know, they are instruments. So there's negotiable instruments. So if those are your conditions, so if I send them a check and I have conditions written on the check and they cash the check, obviously they agreed to the conditions. They cashed the check. If they didn't cash it, they should have returned the check to me if they didn't like the conditions, right? So if you cash this check with my conditions on it, you agreed to my conditions, whatever my conditions are. So I'm not saying that it's wrong, but by deduction, that reasoning makes sense.
Right. But it's also putting you in agreement that this debt is valid or whatever.
Well, not necessarily.
Okay.
What outcome do you want? If I say, if you cash this check, you're agreeing that you're going to delete this account from all consumer reporting agencies, and this debt will be reported as paid in full, right? And the collection agency, decide to go and cash that check. They just agreed to the terms that I impose on this check. So I'm going to have a copy of it. I'm going to make a copy of the check. So if they ever go in dishonor, I can say that I made conditions on the check. They cashed it. They didn't uphold their end of the bargain. That gives you room to go into sue.
Oh, okay.
It's whatever your desired outcome is. Remedy doesn't necessarily mean monetary gain, you know. It could be simply, what if you just want a deletion? That's what you want.
Right.
You get what I'm saying?
Mhm.
So I hope.
Okay. the basic, okay, well, I'll think about that one, but I know you've given us a lot of good information anyway, other than that one, but I always had it in my mind, like, did she
Listen,
say?
there's more than one way to skin the cat. As
Yeah.
long as the damn cat gets skinned and you got your foot on their necks, get
Right.
your outcome.
But that situation is the repo, you've talked to me about that repo, but yeah.
But like I said, if those are your conditions and
Right,
they cash the check, your conditions must be met or you're going to meet me in court with a lawsuit.
correct, okay.
These are my conditions for cashing this check.
Mhm. Awesome. Okay,
Just like an affidavit. If I send you an affidavit saying that you owe me $50 every month and you don't rebut that affidavit, my affidavit stands as law. An affidavit unrebutted after 30 days stands as true in commerce. You owe me $50 for the rest of my life, every month.
right. Good, okay.
All right.
Thank you so much.
You're welcome. Osmond going once.
How you doing, bro? How you feeling?
Bruh, I am out of liquor. Shit. What's up?
What's up? So I just wanted to add a quick question. How do you take them to court? Like,
What do you mean? Wait. All right, let's rephrase. How do they take you to court?
they send it in the mail. I know court starts in the mail, but I just wanted to be.
No. Let's deduce it. How do they take you to court? They're gonna send you a summons, right? And they're gonna tell you to appear in court, right? The same thing that they're able to do, you're able to do the exact same thing. There is no difference. Like, we think that they have power, they have none. The Fdcpa just told you that they don't even have no legal right to sue. Legal actions by a debt collector, Congress told you they have no legal right to do none of that.
All right.
So go get your remedy, invoke your specified remedy. Shit.
Okay.
Whatever
Cool.
your specified remedy is.
That was all my quick. That was it.
All right, let's go. Appreciate
And
you.
wait, one more thing. My bad. One more thing. So I heard you tell somebody earlier. So I know we've been dealing with this for a while. So if you've been dealing with this for a while, let's say like 18 years, you didn't handle this. Can you still go get your remedy if it's been some time?
When you say handle this, I'm not sure what you mean.
Like if let's say if you've been paying on a car note for 5 years or something like that or whatever, can you still go back and get your remedy?
There's no statute of limitation on fraud. Did you detect some fraud?
All right, cool. I just wanted to hear from you.
All right, bro. When you find out, then you go get your remedy.
I appreciate you so much for your time tonight.
Hey, no problem. Appreciate all of you for being here. All right, next we have Leah Joe.
Hello.
Hello, Leah.
Hey, I had a quick question on the validation letter. So should we have a lawyer look over the entire letter or a certain section to be tailored to our needs?
No, why would you not have them look over all of it? Look, because remember, it's a guide. You get what I'm saying? It's not a verbatim. So depending on the complexity of your situation and the jurisdiction that you fall in, some things might apply, some things might have to be changed.
Okay.
So you don't want to find yourself in a bind where you're using language that doesn't correspond with where you are. That's why I say go get it looked over and then you execute once you understand what you're doing.
Okay, got it. That was my question. Thank you.
No problem. All right. Samia Scott.
Hi, I just had a quick question. Do you have a course only for the affidavit?
Yes, I do.
Okay, where do I find that?
All right. So Nish, are you here?
Yes, I'm here. I'm following.
Okay. All right. So Nish is gonna DM you, Samia,
Okay.
get your information, and then we're gonna get you connected with the course on the affidavit.
Okay. Thank you, guys.
No problem. All right. Next, we have Brandon Burrows. All right. I think I pronounced it right. Brandon going once.
Hey, can you hear me?
Yep. What's your beef, bro?
Hey, what's going on, man?
Who you got beef with? Let's go.
Oh no beef, man. Credit, no. Well, I got beef. So, but not major, or it's major enough. So, yeah, I was at work and trying to go outside. So, I've got no collections or delinquencies, anything like that.
Mhm.
But I do have 200,000 in student loans, man. Is there? Yeah, man. And
Are you a doctor?
I gotta go. I mean, no. I mean, I'm a law school dropout, but I've got a master's. But I mean, it needs to stay. I
You
should
don't
have
even
200,000.
need all of that to get rich anyway.
Literally. So, I got a heavy student loans.
Mhm.
I've been in and out today on your lecture, but is there? I bought the ebook. I saw some letters in there. Is
Mhm.
there anything additional that I need to do in regards to those student loans, but outside of what you already have on
So
your platform?
what my platform and what I teach can take it off your report.
Okay,
But
cool.
as to you owning or owing the debt, that is something up to you and what you're going to have to do if it's going to be an alleged debt or an obligation.
No worries about the owing it. I just want to get it off so I can
Too easy.
finance a couple more properties.
Which packet did you just buy? The ebook by itself?
I bought the ebook with this course.
So you have did you get the bundle?
I got the bundle. Yeah, it was like 40. I think your ebook was like 43 pages.
Okay, so if you have no, so the bundle was when I was doing the $4.99 special.
Oh no, I didn't do that then. No, I think I only paid like $250.
So yeah, so it sounds like you probably got the silver or the beginners package. So there's certain tiers. If you go on the website, depending on which one you got, it sounds like you got the Zoom and the beginners package. That's probably what you got. But there is a student loan deletion letter that comes with the silver package. So I'll tell you what I'll do. Nish,
I'm here.
for Brandon, right? Take Brandon, DM Nish directly your email address and put Daraine said he would give me the student loan deletion letter. I'll give you that for free.
You said, oh my man, that's gonna take me to another level. I mean, my score is like a 7, I think it's like a 770. And I had a late payment pop up when I was trying to do a dispute before. A late payment just popped up from 2018 that they added on, and I had like I think it was like an 835, and it dropped me to a 770. So
bro, we know late payments illegal.
I know. I learned that. I learned that the other day listening to you on Clubhouse. So no, that's
it's in the book
period.
too.
I'm getting it's in the book that I bought. So I'm not worried about that one. I'm gonna get that one rid of that one, but I want to get these student loans off, so I can qualify for more bang for my buck. That 1% is killing me right now.
Okay.
So
yeah, DM Nish, direct message Nish.
How you spell her name?
Nish, she's a co-host. Look in the participants, and you're gonna see Nishalee Marsh.
Okay, I'm looking here.
She has a heart beside her co-host name. I don't know how she did that, but I don't know how she put the heart there. But just DM her, and we'll get you that student loan deletion letter. Don't worry about it. I'll give it to you for free.
Man, I appreciate you. I do not see her in the participants.
Don't worry.
There it is. I see her. I see her right there.
She's gonna get in contact.
Daraine,
I'm,
say my full name. They said Nish, it's Nichelle. The whole name
Bruh,
is
I
there. That's
said
why.
it. Bruh, I said it initially March.
um, Michelle Marsh, Michelle Marsh, did you
I
get my
got it,
DM?
Brandon. I got you. I got you.
All right, so we're gonna take care of you, all right, Brendan?
I appreciate you, man.
I
Thank you.
don't, so remember, we can only give you the information. The execution is all on you. So whatever your
Oh,
remedy is, it's all on you. I'll give you
man.
the tools, but you gotta use it.
Oh, I'm sending that joint out as soon as it touch my inbox.
All right, most definitely.
All
All
right, thanks,
right,
man.
we have next. All right, thank you a lot, Brendan. Next, we have iPad.
Hi, Daraine, that's me. I was the one last minute trying to get in here, so I don't worry about my name or nothing. I was just trying to get in here.
Well, what's your beef? Who you got beef with?
I think it's like Milling Credit or something like that. I sent them a debt validation letter, and then they sent me back like a whole history of bills, and I'm like, oh no, where do I go from here? Like I know bills they don't mean nothing about
Well,
validation or nothing,
we
but
just
they're
went
just
through it,
bills.
and you see that all of that is bullshit.
Yeah.
So now this letter that you're gonna get tonight, you're gonna hit them with it.
Okay, so I can send that letter to them again, like as a debt
Goddamn
validation.
right.
Yeah.
Is that so? Basically, remember the opening statement. I asked you for a validation of debt, and you gave me a computer-generated email with bills and statements. I never asked for none of that. Give me all the 5 points that Congress says you're supposed to give me under the Fdcpa for validation of debt, 15 USC 1692G, right? For each one that they don't give you, that's a violation. In addition, you're going to send out the validation of debt proof, proof of claim with all the sauce inside of it. That's why, like, y'all need to spend a good 3 weeks to a month. Don't just get this letter and send it out tomorrow. Please understand the contents of the letter. Please, please, please. Daraine will not be responsible for anybody's failure to implement and understanding the contents of the letter, and if you don't seek legal advice, if you're unsure about something.
Okay.
You will get the tools. Spend the time. It's not a race. The shit's been there for years. It's still going to be there for a few more years. Spend the time and understand the letter. Ooh, my man Bashir, I see you, man.
Yeah.
Thank you up.
He definitely been putting game in the chat. He been, yeah.
Share, yes, he's over here coming in hot, Daraine, with
Yeah,
you.
definitely. Thank you so much, Daraine. Thank you for tonight. You're amazing.
Problem. Thank you
Thank
very
you.
much. Thank you very much. All right, next we have Sean Simon. Hope I pronounced it right. SS, Sean Simon.
Hi, it's Sean
What-
Simon.
Oh,
How are you?
hello, beautiful.
Okay.
How are you?
Oh, I'm good.
Ooh,
Thank
I'm
you.
loving them glasses.
Okay. My husband right here picked them out.
Oh, listen. You should be happy and proud. Them glasses. Ooh, let me take a drink. Take a drink.
No, okay. I have a question for real.
Let's go.
Does a debt collection pertain to owning past rent on a commercial lease?
That's commercial. That's different.
It's totally different.
Yeah, commercial doesn't apply to consumer.
Okay. That's
It's
good
the
to know.
different. Yeah, it's different because one's business. Unless you probably went in there as a co-signer and you're doing some weird shit, but commercial is different when you're operating as a consumer. Yeah, it's different. It's like residential real estate versus commercial real estate.
Okay. My second question is, if my husband and I, we bought a car last year, everything's fine, it's in good standing. He has a really nice car and I have a really nice car too. However,
Hold on, you said we bought a car. Did y'all buy it together? Did y'all co-sign?
Well, I did. No, I did. It's on me.
Okay, good. So we want to keep things separate. So in the event that something happens to you, he is good. In the event something happens to him, you're good. Don't commingle the credit files. Keep them separate because
Okay.
you're gonna have twice
Okay.
the leverage.
Got you. Okay, well, I bought a Porsche last year for he has
Shit.
one, and then
All
I
right.
have a convertible BMW.
Oh,
My
shit.
question is, we did it and everything's fine, payments are fine, but
Mm-hmm.
do we have any leverage to change our status? Because we did not list ourselves. I mean, we're listed as borrowers, we listed as um a loan and all that stuff. So is it possible to change our status, or you only do that when you're in bad standing?
Nah, it's possible for you to do whatever you want to do, but just know they're gonna come after you. But you need to know how to defend
Oh,
yourself. Because if they're telling you about all these different things, I'm imagining you use your social security card, right?
yes.
So you went into a
Yes.
consumer credit transaction, but somebody came back and gave you a loan, which a loan isn't defined under
Yes.
the FDCPA. So now it's about, well, validation of debt. That's number one, cease and desist. And basically, you picking your fight. So if you believe you're able to study, learn the language of the FDCPA, know that you're not a borrower, know that you didn't get a loan, because those aren't defined under the FDCPA, and you're willing to stick this out and take the fight to them, you can get it. You can get away with it.
Okay. And
But
this is my last
don't
question.
don't try something that you're not going to see all the way through.
Okay. I'm only asking. So I'm a business owner, and
Mhm.
I have been enjoying you speaking on Clubhouse, and I figured that I needed to learn all of this back end stuff because I am a businesswoman.
Mhm.
So this is, I've hired a credit person to fix credit before, but you've taught me more than what that person has ever taught me, and I have a deeper understanding. So I definitely appreciate you giving your time. As soon as you said your class, I
Appreciate it.
hopped on it right away.
I appreciate that.
So
Thank you very much.
I think that's it. Um, that's it. I had another question, but I don't need to ask that. So
You
thank
sure?
you.
If you have another
Yep, I'm
question, I
positive.
don't want you to leave not getting your question.
Okay. If I hired a repair person maybe like 2 years ago, and I paid them to repair the credit, but we didn't go. No language was ever discussed about going after them to sue them for damages. Is
Mhm.
it possible that they sued them for damages and got the money on my behalf?
Well, if that happened, then that's fraud, and you'd have to be able to prove that. Um,
Okay.
not everyone disputes the same way. Some people use what is
Okay.
called Metro 2, some use factual disputes, some people ask, please, can you remove this? Like, there's many different ways to do it. Some people send a
But this
million
seems the
letters.
better way. This seems to be like the better way
Yeah,
if
so
we're
like
gonna get paid.
it's not really that one way is better than the other, but I find the laws to be very effective.
Okay.
Yes,
Okay. Thank you so much.
you're
Thank you.
absolutely welcome to it.
All right. Thank
No problem. All right, Bashir, we're finally at you, bro. What's up with that drink?
Oh, it's almost done. You hear me?
Yeah, go ahead.
Yeah, I said it's almost done. I'm not done yet
What you
though.
sipping on? What you sipping
A beer.
on? All right.
So my question to you is this. I know we were speaking about debt collectors, and what I wanted to ask you is if a debt collector does buy a debt from a creditor,
Mm-hmm.
and they buy the debt, and basically, let's say it's a $2,000 debt, and they buy the debt for, let's say, $10. Isn't it illegal for them to actually come after you for the whole amount? They're only owed what's due, correct? Like
Maybe it is, maybe it isn't.
because
Right.
they didn't buy the debt single-handedly each account. What most people don't know is they buy that debt in a big portfolio. So it's millions of accounts.
True.
So
And
you don't really know how much. Yeah.
And there's unwritten adjustment. However,
Yes.
that's not your business. What's your business? Your business is I don't care what you do, just don't come after me because I know the FDCPA. And if you do, that $100 that you're trying to come after me for is going to be 10 grand me coming after you.
Well, I was trying to tie that into the mail fraud that you talked about earlier.
But
So if in fact,
it is deceptive forms.
yeah, that's what I'm saying. So you're saying I owe $2,000, but in fact you actually paid $10, which makes it mail fraud because I don't actually owe you
because now
$100.
you're collecting on an exaggerated amount.
There you go. That's what I was trying to get at.
This is where now knowing the different portions of the law, like you should be able to speak this thing off the back of you, the back of your tongue. So like if they send you a rebuttal, you're gonna be like, nah, bro, that's bullshit. You can't even sue me because according to 15 USC 1692 I believe, legal action of a debt collector, you have no legal right to even file suit. Not to mention, if I ever get any correspondence from an attorney, 15 USC 1692 E3 says that no communication or implication should be even coming from an attorney. So what are we talking about right now? You get what I'm saying? So when you're able to get them, whatever they do, just do whatever y'all are doing, but just don't bring no bullshit to me.
Well, they should leave you alone, especially if you talk about mail fraud. That's actually something that really scares them.
Did you write down the section for mail fraud?
Huh?
Did you write down the section for mail fraud when I said it earlier?
No, I did, yeah. But what I'm saying is they're really scared of mail fraud. That's something that they could really get punished for.
20 years in prison, bro.
Yeah.
Read the rest of it. It's up to
You ever seen that movie? You ever seen that movie with Tom Cruise called The Firm?
No.
Watch that movie, because in that movie, Tom Cruise gets into a crazy ass jam with his law firm. And he gets out of it because another lawyer, this black lawyer, basically tells him straight up, like, you got them for overbilling. The law firm had overbilled, which is what we just talked about. When you overbill and you send it in the mail, it's mail fraud. So he was able to get out of a huge jam because he caught them on mail fraud. It's crazy. So it's called The Firm, but you got to watch that movie.
Yeah, mail fraud is huge, especially if you're using the government as the carrier. That's what the penalty is so much, because USPS is owned by the government. So now the government is aiding and abetting your mail fraud. You get what I'm saying?
It's two post offices. That's what messes them up.
Yeah. So that's really basically it. But study that.
I don't got no more to say. I just wanted to touch bases with that. Yeah.
Oh, good, bro. All right. Next we have Shamar Robinson.
Hey, what's up, bro? Can you hear me?
Yep.
Good deal. Hey, so my situation is this, man. I actually had a repossession back in 2016. And I was actually sued by the finance company towards the end of last year. And I, not knowing these laws, settled out of court. So is there a way that, I could use this validation letter or some other method to?
So what I'll listen, Daraine does not give legal advice, so I gotta, throw that out there.
Okay.
I'd find me an attorney, and based on new information, I am going to reopen that case because I found out that I was frauded out on a transaction. So what you're going to do is present the evidence. So you're going to put your exhibits together, everything that you know now, especially under the law, find all the violations, and you are going to go after them. And you know that the Sixth Amendment right, you have the right to face your accuser. So I don't need to see no lawyer. I want to see whoever XYZ financing company is. Show up to court. I'm invoking my Sixth Amendment right. And guess what? A paper cannot show up to court. What are they going to testify? It's a piece of paper. A corporation is a piece of paper. So now you win by default judgment. Even though we know default judgments are illegal, but it's illegal when it's being used on the natural person.
So we actually settled out of court. There was no default judgment.
No, I'm not saying that there was any default judgment. I'm saying if we're gonna go after them, this is how Daraine would go after them if I was in your position.
I need to secretly get a lawyer for this.
But it's not just getting a lawyer, because they're not going to know the shit that you're going to be telling them. So you need to be able to break down the law, show them all the proofs and the exhibit that you were frauded and that you were coerced and misled with deceptive forms to do something that you did not understand.
Got you. Okay. Makes sense. All right, boss. I appreciate it.
Appreciate you. No problem. Daraine, you still with me?
Yes, hi.
What's up, family?
How are you?
I'm good. I'm good.
Okay, good. I have a question. So the validation of debt and the assisted deceased, that can be used for a foreclosure as well?
Say again, please.
Can that be used as a foreclosure as well?
Well, so validation of debt, yes. Cease and desist, yes. Foreclosures, we need another part that's missing. Remember earlier I spoke about advertising?
Yes.
So did you write down that section?
Yeah, I have a lot of notes, but I wrote it down.
Okay. So the section that speaks about the advertisement of the debt and to coerce the payment and the publication of a list, you're going to use those to your advantage along with the validation of that proof of claim. And remember, you're only accepting your original paperwork. Rule 1002. Or was it
Yes.
201? I don't
Okay.
remember.
Okay, so let's just say that they provide me with everything that I asked for, and then you said you would take them to court. But what court are you referring to? Is this civil court?
These are federal laws. These are federal laws.
No, it would go to a federal court.
I'm not telling you that's where you should go, but these are federal laws.
Okay.
So I'd act accordingly.
Okay. Okay, great. Thank you.
No problem. Okay. Now we got Edward. Edward going once.
Yeah, how you doing?
Hey, what's going on? I'm almost out of rum.
Oh, okay. I got a question about a old credit card debt that he put on my report. It's charge off. I can't seem to get it off.
So it's a charge off that you can't get off. Okay.
Right.
Is it only listed as a charge off? Is there anything else beside it?
No, it's just listed as a charge off, and it's got a debt owed, and that's it.
All right. So for the credit,
And I even talked to the people who called me about it, and they said if I pay the debt off, then the company that reported it, they'll take it off because they work for that company.
bullshit. It sounds to me like there's some collection company involved.
It might be, but I can't seem to get it off. And I even tried to pay the debt off through the credit card company that I owed it, and they wouldn't even take it. They said you got to go through that company.
Collection. So it's in collections. It's in collections.
It's on my report of the charge off.
Yeah.
Want to get it off.
But it sounds like it's in collections. Okay, good. So that's fine. So if it's listed as a charge off, remember what I said about the 1099-C?
Right. I asked them about that. They told me that they don't have to show me that because they was the one who wrote off or something.
Okay, so go right now, type in Google how to report tax fraud, and it's going to bring you to the IRS website. And
okay.
You're gonna file a claim. You're gonna file it there. You're gonna go to the Do you have a pen?
Yeah.
You're gonna go to the CFPB website. You're gonna file it there. You're gonna go to the FTC, Federal Trade Committee. Federal Trade, one of them.
Federal Trade Commission.
It's all different government agency. Federal Trade Commission, there we go. Federal Trade Commission, I'm drinking too much. Federal Trade Commission, and you're gonna file it there. Then you're gonna go to the BBB, the Better Business Bureau. You're gonna file it there. All of them, you're gonna file that the company at hand is filing tax fraud because they're reporting an account as a charge-off. You requested the 1099-C so you can file it with your taxes, and they are refusing to give it to you.
Okay.
Right? Then from there, now you're gonna hit the collections company with not the, because if the collection company, so are you sure the collection company didn't report it at all?
Oh, I don't know. I got it off the, what happened was I seen on my credit report and I contacted the company and to see if I could pay it. Actually, the company who it was with was Navy Federal. So I contacted them to try to get it off and they said if I could pay it, I had to go through the other.
Okay, so if it's been reported